Southampton Zoning Board of Appeals. This meeting is being held live and also via video conferencing in accordance with the Town Board's enactment of Local Law Number 14 of 2022. Our next meeting and those following will also be held in person here at Town Hall and will continue to allow for remote participation. So please keep checking the town's website for updates and any new information. If you wish to view tonight's meeting live only and not participate, please do not join the Zoom meeting and instead go to the town's website for viewing access. With that, I'd like to ask you to join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. For those of you with us here tonight, in case of an emergency evacuation, please exit through the rear doors of this room to one of the staircases across the hall and continue downstairs and out through the main entrance. Do not attempt to use the elevators during an emergency evacuation. In a case of a medical emergency, the automated external defibrillator and first aid kit are both located in the hallway on this floor opposite the elevator. Restrooms are located across the hall from this room. We'll begin this meeting with public hearings. We have applicants and members of the public here with us live and also standing by via Zoom webinar, which is being moderated by CTV. CTV will mute the speakers on Zoom until it is their time to give testimony before the board. Please be patient. If you find you're having difficulties accessing the hearing, visit the town clerk's meeting portal and click on the instructions link. Also, for those of you in the boardroom, please silence your cell phones and refrain from speaking to one another as it interferes with the recording of our proceedings. Tonight, board member Helen Burgess is participating via Zoom, and Carrie Meyer will be covering the meeting for Candace Cowell. A reminder that applicants, agents, and members of the public speaking other than attorneys will be sworn in, will state their address for the record, and will offer their testimony as it relates to the application before the board. In order to consider properly every application before us tonight, individuals commenting on a particular application have a time limit of 3 minutes. Also, before handing in any submissions to the board tonight, please make sure that the documents identify the ZBA application name and tax map number. The application name should also be written on your certified receipts. Unless otherwise stated, at the end of an individual application hearing, all applications will remain open for written comments for all purposes until a set date. In the temporary absence of the board secretary, Candace Cowell, those written comments can be addressed to the members of the board and sent via email, mail, and or dropped off at Town Hall to the attention of Maylin Ziesman. Ms. Ziesman is located in the building department. At this time, I'd like a motion to approve both the minutes of our August 1st and August 15th, 2024 meetings.
Motion to approve.
Second.
Mr. Leonard.
Aye.
Mr. Mastodio.
Aye.
Ms. Kane.
Aye.
Mr. Revin.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Chair votes aye. John, would you like to take us through the agenda?
Yes, turning to number 10 on the agenda, this application, John T. Montecalvo et al., 1129, 1089, and 1169 Spionk River Head Road, Suffolk County Tax Map number 900-300-2-6, 7, and 8, will be adjourned to November 21st.
We have to second that? Yeah. Second.
Mr. Leonard.
Aye.
Mr. Macedonia.
Aye.
Ms. Kane.
Aye.
Mr. Revin.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Chair votes aye.
No, turning to application number 12 on the agenda, 50 Clearview LLC. This application has been withdrawn. No vote necessary. Turning to number 18 on the agenda, secret resolution, the lead agency resolution in Wilderness Trail JV LLC, Suffolk County Tax Map number 900-79-1-33. Lead agency resolution will be adjourned to November 7th.
Second.
Mr. Leonard.
Aye.
Mr. Macedonia.
Aye.
Ms. Kane.
Aye.
Mr. Revin.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Chair votes aye.
Turning to the decision calendar, decisions in Lewis and Clark LLC, Michael Teitelbaum and Michelle Teitelbaum, Isaac Furman, and Charles and Doreen Levine will be adjourned to our September 19th meeting.
Second.
Mr. Leonard.
Aye.
Mr. Macedonia.
Aye.
Ms. Kane. Aye. Mr. Redmond.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Chair votes aye.
Okay, starting with number 1 on the agenda, Evan Jaffe and Jennifer Jaffe, 16 Oak Road, Noyak, Suffolk County Tax Map Number 900-5-2-50. Applicant requests relief from the following provisions of the Town Code. 1, to legalize the expansion of existing deck without the benefit of a building permit on a non-conforming lot. Section 330-11, Residence District's Table of Dimensional Regulations for an accessory side yard setback of 2.2 feet, where a minimum of 8 feet is required from the south property line, and 330-76D, placement of accessory building structures and uses in all districts, and 330-83C yards, to allow the deck, this portion of the deck to remain within the required minimum and total required side yard for the principal building. 2, for a proposed second-story addition to the existing dwelling, section 330-84D, height pyramid, for a total pyramid encroachment of 2,118 cubic feet, 373 cubic feet existing on the south side, 188 cubic feet existing on the north side, 3 cubic feet proposed on the north side, and 1,554 cubic feet proposed on the south side, and 3, for a total lot coverage of 21%, where a maximum of 20% lot coverage is allowed, and any other relief necessary.
Board has jurisdiction.
Got it.
We swear to Lori.
Lori Wiltshire.
No, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Please state your name and address.
Lori Wiltshire, office is at 231 Pantego Road, Land Planning Services, representing the Jaffes. And the application is for permission to construct a 591 square foot second story addition to the existing house and to legalize a wooden deck running along the southern side of the house, which is situated in a required side yard. The proposed work requires pyramid relief as the subject property is less than 58 feet wide and only 5,006 square feet in an R10 zone. A small lot coverage variance of 47 square feet is requested, as is minimum and total side yard relief to allow an existing deck, which is actually a 4-foot wide walkway, to remain. Granting of the requested variance would not cause an undesirable change in the character of the neighborhood, nor would it create a detriment to nearby properties. Most houses in the neighborhood are pre-existing and non-conforming with respect to the pyramid law and other setback restrictions, and many have received variances from both the pyramid law and setback requirements. This is the neighborhood of Pine Neck that we're talking about, historically undersized lots all around. The proposed addition would be compatible with the neighborhood and increase the value of nearby properties. The total pyramid relief is under 3,000 cubic feet, which is well within the character of the Pine Neck neighborhood. The deck walkway running close to the southerly lot line was constructed sometime after 2007 by prior owners and does not have an adverse effect on the neighborhood because it is not wide enough to hold furniture or to entertain on, therefore noise is not a consideration here. In fact, the immediate neighbors to the north and south have written letters in support of this relief. One of them states that they believe the improvements to the property will benefit our street and neighborhood. I believe these have been sent into your record. There's one from the owner of 18 Oak Road and one from the owner of 14 Oak Road. But if you like, they're very short and I can read them into the record.
Would you do that? I'm not sure.
Okay. So Margaret McCarthy of 18 Oak Road wrote a letter on August 26th saying, I've reviewed the proposed plans and elevations for variances requested by my neighbor to the south at 16 Oak Road and have no issues with the board's approval of the same. And August 26, 2024, Joy Cusick and Michael Friedman wrote.
Where are they? What's their location?
They are 14 Oak Road. So this is either side of the house. They're both on Oak Road. Our house and property are located directly adjacent to 16 Oak Road, owned by Jennifer and Evan Jaffe. We're writing in support of the Jaffe family and the proposed work to their home at 16 Oak Road. Michael and I have been residents of the Pine Neck neighborhood in Sag Harbor for over 10 years and are delighted by the continued investment in our community. We have had opportunity to review the plans proposed by Jennifer and Evan and believe that the improvements to the property will benefit our street and neighborhood. This I will give to Katie for the record so that you have a copy.
Okay, thank you. Is there anything else you wanted to say in support of the application?
Yes. So the existing house currently stands 6.5 feet off the southerly property line. It was built in approximately 1956 and is only 1,100 square feet in size. It contains 3 bedrooms, 2 of which are very small and only 1 bathroom for this family of 4. A proposed cape design with dormers minimizes the appearance of the size of the second floor addition because the new space is contained within the roof area. Alternatively, a full 2-story design, such as a colonial or a farmhouse with a full 2-story plus a roof, might require twice the pyramid relief. The ceiling height for both the first and second floor will be 8 feet, and the ridge height will only be 24 feet 6 inches. Every effort to minimize the visual impact and to fit in with the neighborhood has been made by the architect. The benefits sought cannot be feasibly achieved by some other method other than the variances. This is a small lot in a neighborhood full of extremely small lots. The lot is undersized by 50%. The variances sought are not substantial, and the proposed addition is compatible with the neighborhood. I don't want to repeat myself. The lot coverage variance is only for 47 square feet. The granted of these variances will not have an adverse effect or impact on the physical or environmental conditions in the neighborhood. The former owner installed a new IAOWTS, and that's already been installed, and they were actually anticipating constructing the second-story addition when they sold. So that's already there. It's an environmental benefit. Due to the constraints of the pre-existing non-conforming parcel, a request for relief from the pyramid law for the proposed residence is the only avenue available to the owners. Additionally, the existing house is not centered on the lot. It was built closer to the southern lot line. There's no alternative location for the proposed second-story addition, and the existing walkway, which would be, there's no location that would make them more conforming. I did a brief glimpse of some of the other pyramid variances that have been granted in Pine Neck, and going back from 2009 through 2015. A lot of them are much larger than what we're asking for here, and that is because the lots on Hampton Road in Pine Neck are long and narrow lots leading out to the water, but they all need relief because they are narrow lots, which is very similar to what we're asking for here. And the most recent one that we handled at 162 Noyak Avenue, the grant of pyramid relief was 4,263 cubic feet. So basically,
What year?
That was in 2015. So these are, it's the case all over a lot of the pyramid encroachments are pre-existing. They don't have variances, but they're very visible when you look at the aerials. Oops, it's gone. But when you look at the aerial photograph, you can see that most of these are right on top of their property lines. Whether they're 1 or 2 stories, they're already encroaching on the pyramid lines. It is very characteristic of the neighborhood. I don't think we're asking for anything out of character, and we do have that support. So I would submit these, a copy of these zoning board decisions for the record and make myself available for any questions.
Kevin, this is your
Yeah,
application.
thank you.
Do you want to start us off?
So, I appreciate your characterization of the situation your client finds themselves in. And a couple of things that struck me. I did go through the neighborhood. There are some taller and 1.5-story buildings. Most of them, there's a couple of newer ones. You could tell that they have been done somewhat recently. But there's also fishing shacks from 1956
Sure.
that are still there in their present form,
Absolutely.
size, and character. So the thing that struck me when I went around was it's not clear to me what the community sees itself as, a bunch of 2-story, 1.5-story, or single-story buildings, which is what a lot of them are in that picture right there. And you know, I'm having a real hard time with, even though I understand that you're proposing something like 500 square feet more, it's a heavy pyramid relief for the square footage requested on a lot that's almost a 1/9 of an acre.
Yes.
Right? So, and the concern I have is, you know, are we going to be doing that on every other applicant coming in? And I think that changes the character of the area to the extent that you know, our duty is to grant the smallest relief necessary. I'd ask you to think about whether you could do better on your best effort so far to have the request be smaller, and figure out how to address that somehow more. And it may be annoying, but that's our job. Or at least that's how I see
It's not
my
annoying,
job.
but it has been contemplated by the architect.
I get it, and I do appreciate the challenge. don't think I've ever witnessed a 5,000 square foot lot somewhere that was trying to be a story and a half or two. So I get the challenge, and those were the things that struck me when I got there. Just for kicks for another time, but I didn't see where the septic system is on the lot. I'm assuming it's not under the deck and it's somewhere in the backyard, not in the front, but I don't know.
It is in the front yard,
Okay.
and the IA itself is under the driveway.
Oh, all right. Okay, thank you. Because I
Yep.
was just curious how that happened.
It won't interfere with what we're proposing here.
Okay. Anybody else with thoughts, questions?
Yes, I also went to see the property. It's a very small lot. And what I think you're proposing, we've seen this before, and, I know a lot of the pyramid reliefs that you're referring to occurred quite a while ago. We see a lot of this, and we see what looks like small lots, middle-sized houses on small lots. And we also appreciate the fact that people are moving out here, they want to make this their home base, but I have a real issue with the amount of pyramid relief being requested. Also seems to be skewed to the one side of the property.
Totally.
And what is the reason for that?
Because that's where the house is.
No, well, the house is centered.
The house is not, it is not centered. It's only 6 feet from the one property line.
Yeah, I understand, but I mean, the pyramid relief is predominantly on the south side, or the north side.
Right, I think what the chairman is saying is that the additional bedrooms could be placed skewed more towards the center of
The
the
center of the
home.
house, yeah.
I'm in agreement with Kevin on this and with the chairperson. I think that it's a lot of relief. One thing that I would say, though, in reference to what you just said about what our duty is, I don't believe our duty is to grant the smallest relief or least relief possible. I believe our duty as a zoning board is to grant relief where appropriate. That's the only correction I
I
would make.
stand
with that.
corrected, thank you.
No, I think it's minimum relief. It
Minimum
is- it
relief
says
necessary.
Minimum relief.
Right.
But to grant it where it's appropriate.
Where appropriate,
Right.
yes. Yes,
Okay, thank
for
you.
sure.
So yeah, I think I would have an issue granting this as it stands.
And I would have to have the architect address that, because I can't specifically speak to why it's centered on one thing.
It's skewed to one side.
Skewed
Well,
on
I'm
one
not
side.
sure that moving everything into the middle it's just gonna shift which
It-
side
it
you're
is
gonna
gonna
have the
shift.
pyramid
It may,
relief.
but it may also slightly reduce it if you look at the scheme. But
But you also have to remember that the people affected by this are the ones that have written support of it, which is different than a situation where someone's saying, hey, don't block my air, don't block my.
I
My light.
appreciate that, but we have to look at the larger picture as well in terms of how we grant these things and the message that we give out to the public in terms of where we are on pyramid relief. So it's not just that the neighbors are okay with it. I mean, the neighbors currently are okay with it. But the other thing that you were talking about, Lori, I went around the neighborhood and I was with Kevin. I mean, there are a couple of places where you've got 2 stories or 1.5 stories, but predominantly 1 story. Small.
And the bigger, and the ones that did have 1.5 or 2 stories, those were noticeably larger lots than
Yeah.
this one.
Yeah.
And this is an issue we run into. I mean, a 1,600 square foot is almost normal for Hampton Bays on a half-acre lot.
Yeah.
So, it's a question of mass, size, and I know you know it because you've been there. The streets are really narrow.
Very
I
narrow.
went there on the weekend. I get it. It's very walkable and bike friendly.
It's a lovely
And
neighborhood.
people
Absolutely.
are walking with strollers. So the size matters when you walk down and go, what happened there?
Right. Well, I mean, the size also matters for a family of 4, when you've got to make some, at least
I
add
get
another
it.
a bathroom, and at least have 3 decent-sized bedrooms.
I'm the last person that should ever design anything, but I noticed that the rooms were not excessively sized,
Right.
and whether you can do with 1 bathroom and whether you can orient the roof in a place that requires less variance for a pyramid, we'd ask you to think about that.
Is
I
what
will
is
have the
mar-
architect address that.
Is what is marked as a den on the first floor, would that be available as a bedroom? That's another thing that could be a
It's a fair
possibility.
question, right?
That's a very fair
And then maybe you only have 1 bedroom upstairs with a
And
bathroom.
and a smaller addition.
Exactly.
I
You
can
can pull
ask
both sides
them,
in.
I can ask them about that.
And again, we appreciate the fact that, the neighborhood's lovely, people want to come out here on a more permanent basis, they have larger families, but the neighborhood wasn't designed for that, in a way. And, we're trying to, try to keep it under control.
Mm-hmm.
And so I think you got the message that we would really
Yeah.
appreciate if you could speak with the architect, the
Yes.
family,
Yes,
see if
absolutely.
there's some jockeying around, maybe build it out to the back, I don't know, but some other ideas that could reduce the pyramid relief. I have no problem with the deck. I mean, it's very heavily vegetated on the side. And you're
Yes.
right, it's a narrow, it's not a party deck. You're not grilling out there with tables or anything like that. It's a walkway and it's really, you can't even see it. I mean, it's just heavily vegetated. So that's not a problem for me at all.
Okay, so we'll address the comments that have been raised.
How much time would you need?
Let's give us 1 month and I'll ask for more if I need it.
Okay.
So that's October 5th, right?
October
I gotta see
3rd.
if anybody's-
No, we're going to have to ask the audience and Zoom
Oh,
before we move on.
Yep, yep.
Is there anyone in the
Our next
audience
date's
who
on
wishes to be heard on Jaffe and Jaffe at 16 Oak Road? Is there anyone on Zoom who wishes to be heard on 16 Oak Road? Okay, Kevin, minute's yours.
Okay, so why don't we hold it open until, which?
You want October 17th?
Let's go 17.
Okay.
Let's hold it open to October 17th.
Second.
Thank you.
Mr. McDonald?
Aye.
Mr. Leonard?
Aye.
Ms. Kane? Aye. Mr. Macedonia?
Aye.
Mr. Revin?
Aye.
Ms. Burgess? Chair votes aye. Okay, thank you, Laura.
Thank you very much.
Thank you. Number 2 on the agenda, application of Dunn Wright Realty Holdings LLC, 9 Willow Shade Avenue, East Quogue, Suffolk County map, tax map number 900-344-1-41.1. Applicant requests relief for the following provisions of the town code for a newly constructed house on a non-conforming lot, section 330-6, general regulations that references 330-11 residence districts table of dimensional regulations for principal total side yards from 45 feet to 39 feet and a principal minimum side yard setback from 20 feet to 19.2 feet and any other relief necessary.
Board has jurisdiction. We pass that to Bob.
Are you an attorney?
Yes,
No.
Laura?
Okay, let me swear. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please state your name and address.
Daniel Collins, 9 Willow Shade Avenue, East Quogue, New York, 41942.
Okay, Mr. Collins, do you want to tell us about the application?
Yes. Basically, I was requesting relief from minimum side yard setback from, on one side from 20 feet to 19.8, and on the other side from 20 feet to 19.2, and relief from the total setback of 45 to 39 feet. Basically, when we were constructing the house, there was a disconnect, which is probably my fault, between me, the mason, and the surveyor. And the house got, I mean, there was multiple drawings over the whole course of the project, and the house got oriented slightly, I guess, further south on one corner. So, and we honestly didn't pick up on it until we were trying to do the permits for the pool. And then it was noticed at the building department. As far as the neighborhood goes, the variance will not cause any undesirable change in the character of the neighborhood or create any detriment. On the same side of the street I'm on, I believe there's only one other house that actually has the correct side setbacks and combined setback. And I have the houses here. Oh yeah, number aside from mine, number 13 has a side setback of 10.5 one side, 18.5 on the other for a combined 29. Number 7 has a side setback of 12.9 and 16.4 on the other side for a combined 29.3. And number 5 has one side they have a large setback, 43.6, and only 5.6 on the other side for a combined of 49.6. And number 3 has a side setback of 9.5 with the other side setback of 15.2 for a combined of 24.7. And they have that because they were actually granted a variance for constructing a new house back in 2005. And they also got relief for the rear setback at the same time, and for the pyramid and total lot coverage. As I said, the house is already there. It's unfortunately, it wasn't noticed until the end, and I can't think of any other feasible way to meet the 45 combined or the side setbacks.
Okay. A question.
Yes.
The way it was written up, we talked about 45 to 39 feet for total side
Yes.
yards. But we only listed one minimum side yard setback of 20 to 19.2. And you were saying it was really 20 to
Oh, yeah,
19.8 also.
Yes.
So
Once
the one,
yeah, when I submitted new surveys. When I submitted originally, the survey wasn't counting the overhang roof. I guess it's on the side property, which is considered the front. So when that was taken into account, they had me submit new surveys.
okay, so it
Wouldn't that
should be,
fall under any other relief necessary?
I don't think it's necessary, because I think what it is the 19.2 is the minimum side, and when you add that to the 19.8, you don't get 45.
You get 39.
Right.
yes, I understand, but the minimum side yard relief is 20 feet for both. So it's 19.8 and 19.2. So I just want to make
Oh, I
sure
see what you're
that,
saying.
I want to make sure we
Advertise properly.
cover everything
Yeah.
so that you don't have to come back and
Yeah.
say, oh my gosh, we forgot.
You know, I was asking.
Right,
for
but we
relief
can
on
we
both
can grant
sides.
that under any
Yep.
other relief necessary,
Yep.
right?
As long as we're aware of
We
the
don't need to
fact that,
advertise it.
What?
We don't need that.
I don't know why it would be a problem just mentioning it, but.
Yeah.
it's-
We don't need to advertise that, Katie.
No,
do
we
we?
don't need to
No.
advertise.
No, I mean, I'll confirm that, but I see what you're saying.
Okay.
Bob, this is yours. Do you want to say anything?
I don't. It seems relatively minor relief. It's not going to change the impact of the neighborhood at all. Don't think you're asking for much. Whatever.
Technically would have qualified for a minor variance under that
Yeah.
scenario.
I'm just gonna say
Exactly.
we have about, a little less, about 9 inches on one side and then 6 feet. I honestly have no problem with it.
Have your neighbors had anything to say at all?
Oh, originally, when we got a variance last year, only about the pool. They haven't, since we posted the sign and did the mailings, they haven't said anything about it, and they were out, everyone was out this last weekend, and they're out there. Our one neighbors on one side live next to us, so they're older couple, they see them all the time. They haven't mentioned anything about it though.
Yeah, I have no issue with this. Is corrective.
Yeah,
Yes.
it's correct, and it's
And
minor.
it's minor.
It's very minor. Anybody else from the board wish to comment? Is there anyone in the audience who wishes to be heard on Dunright Realty Holdings 9 Willow Shade Avenue? Is there anybody on Zoom who wishes to be heard? Okay, Bob, this is yours.
Okay. We close the meeting, public hearing, hold it open for written submissions until September 20th with a decision on October 3rd.
Second.
Mr. Macedonia?
Aye.
Mr. Leonard?
Aye.
Ms. Kane?
Aye.
Mr. Redden?
Aye.
Mr. McDonald?
Aye.
Ms. Burgess? Aye. Chair votes aye. Okay, thank you very much.
Thank you. Number 3 on the agenda, application of Laura T. Natasi, 18 Old Scallop Pond Road, North Sea, Suffolk County Tax Map Number 900-60-1-6. Applicant requests relief from the following provisions of the Town Code for detached garage. 1. Section 330-6, general regulations that references Section 330-11, Residence Districts Table of Dimensional Regulations for an accessory distance from street setback from 70 feet to 29.8 feet. And 2, Section 330-76D, placement of accessory building structures and uses in all districts. And Section 330-83C, yards, to allow the detached garage to be located within the required front yard for the principal building on a non-conforming lot and any other relief necessary.
The board has jurisdiction. Can you give this to John Redden?
I need to
John, you
swear
just
you
put
in.
that original in the file.
Do you swear to tell the truth, the whole truth, and nothing but the truth? Please state your name and address.
Sean Leonard from Twentyhampton.
And Mr.
David Gilmartin, Greenberg Troy, 2317 Montauk Highway, Bridgehampton, New York, for the applicant. This property, to orient you, is in the Conscience Point section of Southampton. which if you've been to the area is a beautiful sort of quintessential Hamptons cottage community. I think the best way to describe what they're doing is to look at the site plan that's shown prepared. They only have 7 copies, so if you could share it. So what the applicant is looking to do is to relocate the garage from here to here so that they can put a swimming pool on the property. The challenge that we face is that in doing a renovation, that they upgraded the septic system on the property. You can't have the driveway come over the septic system. So that's what drove the garage over to that section of the property. So obviously a grant of the variance will allow us to relocate the garage and be able to install a pool. I also have aerials of the area, which I think really demonstrates the fact that there's not going to be a detrimental impact to the community.
Thank you.
And if we look at the property, which is here,
Who was the second? Sorry. Go ahead.
so if we look at the property which is here, and flipping the garage, it can only affect the property across the street. The property directly across the street has a structure here, which is a garage, which will be exactly where
Roger, why not?
the garage that we're proposing would be. I would also note, because I represented this family as well, that they got a variance from this board, differently constituted, I don't know if any of you were on the board then.
No, don't think so.
For an accessory apartment in a separate structure that was more than probably 50 or 60% size of the house. Was the house on that property is beautifully historic, but also really small. They haven't installed that yet, but they have gotten relief from this property. So based on the location and what's happening across the street, and I just also mentioned the significant amount of landscaping that's in front. I mean, it's beautifully done. That will screen it pretty significantly. It's set back from their house, so when the neighbor's on the deck, they're not looking at a garage because it's further down across from their garage. With respect to the substantiality of it, if you look at a percentage from the number, it seems high, from 70 to 29.8. But I'd reiterate the comments that it's a non-conforming lot in an R40 zoning district, so we're squeezed with that in the front yard. So, we're kind of squeezed into the back of the property there. I'd also note that the lot coverage is 9.8% on this lot when you're entitled to 20%. And I think that's really telling with respect to the substantiality argument. There's obviously, because of the 2 front yards and the size of the lot relative to the zoning, and this lot was created before zoning was enacted, that has an effect on our ability to be able to make the switch. So I don't think there's any other way that we can achieve this benefit other than what we've come before you tonight. There's going to be no environmental impact. Again, we've installed the IA system as part of the other renovation to the house, and that's what's actually driving the change here. And type 2 variances under New York State DEC do not have an environmental impact categorically. And as far as the self-created hardship, again, the property was created before zoning, so I think the enactment of zoning is one of the hardships, although I understand it's an accessory structure and we're trying to get a pool, so it's probably a debatable point of self-created hardship, but that's not fatal to the zoning board application.
Can I just ask a clarifying question really
Sure.
quickly? I'm looking at the aerial and the site map. The current driveway is going away that dumps out onto Scallop Pond Road. and is gonna come out instead on Old Field, is that right?
That's correct.
Okay, make sure I understood that.
When you say the property was created before zoning,
The
does
lot.
that mean the lot, but
The lot.
not the structure? Or
I,
was
I,
this-
bel I believe the structure was created prior to zoning, but the,
Okay, okay, I just
Yeah.
wanted, well, it appears to be a very old,
it is.
Oh,
It-
very
yes.
so, okay.
And I say what, but going back and looking at the building department records, there's no record saying
Yeah,
there was,
right,
that it
okay.
was there. There are upgrades through the years where there are COs, but, so that I think the town has obviously acknowledged its pre-existing nature. You know, I also have I have a copy of the Suffolk County tax map, and I'll do this thing more efficiently. I hope.
Thank you.
And I just outlined that one, which I think is just such a beautiful area there. And I circled our lot, which, you know, except for 22.1 and 4, seems to be bigger than most of the lots there. It certainly isn't smaller, like we're trying to cram something in. One of the other benefits of this location of the pool is that the Somme Preserve is next door, so it creates some privacy. You know, in your pool, I think you want to have a little bit of privacy, and that's what creates it here. So I think it's a perfect setup, and that's our application. Sean Leonard, the architect, is here. He can answer any questions, and I'm happy to
John,
answer
this
questions.
is yours.
Well, I don't have any questions. I actually liked your design. I'd like to say that. So I think there's plenty of foliage around. So for me, my personal opinion was I actually thought it was a pretty good setup because you can't see the way the garage, you know, is coming the side entrance. So when you look at the house, you're not looking into a garage.
I went to the property, it's beautiful.
Yeah.
I also noticed that the garage across the street would parallel where you're gonna be. Well vegetated, there's vacant land all over the place. I don't have a problem with this application.
So the only question I have, I generally agree with my colleagues, is where, and I appreciated the trying to salvage the garage and reutilizing it because it's a distinct feature of the property is the landscape and the structure set in the way it is. It's like quite striking, I thought. And there's a little dip when you go, your driveway sort of, right now it looks like a construction driveway, you just drive in.
It's dry, it's dirt.
What's your sense of what the elevation for the garage would be against the existing grade, roughly, if you know?
The intent is actually to keep the garage down low with the
Right,
one with the road.
okay,
And as you can see, that grade goes up, so
Right.
that this way from the house, the garage doesn't get to be too tall next
Well,
to the
that's-
house. The
right.
thought is to keep it down.
and then, of course, if you know the site well enough, I mean, there's some really outstanding cedars all in there.
Yes.
So getting the garage in there is no small feat, which I applaud you for trying to do. And I hope you do it in a way that keeps the substantial trees there still intact, which is a unique feature of the entire site.
So, yes, the family has owned this property since the 70s. And so it's been passed down to the
Parents to daughter.
right to the next generation. And it's their intent because they've been keeping up with the landscaping, is they don't wish to see any of that landscaping go. And it's been talked about many times because the mother has been very active and she's, you know, like, no, I want to save that tree, let's save this tree. And
Okay.
so she's been very much very active in that.
There's
You
not
can
gonna
tell
be
from the
any
way it's
pyramid
kept.
relief
It's
required.
important to the-
Okay, no, I assumed as much, but I just wanted you to tell me.
Assumption.
Okay, okay.
Anybody else from the board who wishes to comment on this application? Is there anyone in the audience who wishes to be heard on 18 Old Scallop Pond Road? Is there anyone on Zoom who wishes to be heard on 18 Old Scallop Pond Road? Okay, John, it's yours.
So did I say close out the meeting?
Yeah, we're gonna, yes, right, we're gonna hold it open for written comments
Hold it open for written comments.
until
September
September 20th,
September 20th.
and a decision on October 3rd.
Second.
Okay. Mr. Redmond.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Aye. Mr. Leonard.
Aye.
Ms. Kane.
Aye.
Mr. Macedonia.
Aye.
Chair votes aye. Okay,
Thank
thank
you.
you.
Have a good evening.
Sure.
Two.
I hope it's.
Numbers 4 and 5 on the agenda, the estate of Rhoda
Hello.
Karpatkin, 12 Peconic Bay Avenue, North Sea, Suffolk County Tax Map number 900-42-3-16. Applicant requests a determination that the subject parcel, Suffolk County Tax Map number 900-42-3-16, is held in single and separate ownership from all adjacent parcels and thus entitled to relief pursuant to Section 330-115D, and 16 Bay Avenue, North Sea, Suffolk County Tax Map number 900-42-3-15. Applicant requests a determination that the subject parcel, Suffolk County Tax Map number 900-42-3-15, is held in single and separate ownership from all adjacent parcels and thus entitled to relief pursuant to 330-115D.
The board has jurisdiction for both. Can you pass those to Julie?
Okay.
And then just
would you
wait
like
one
to-
second because I want to pass
Would you
these
like
out
to
as well.
introduce yourself, please?
Carl Benacasa, 860 Montauk Highway, Watermill, New York, for the applicant. There are some additional handouts that are
So
coming
pass
your
both
way
those to Julie, one for each file.
Yep.
that just help explain the history of this parcel.
Thank you.
Oh, you can get another folders. Wow.
Wow.
I know, really. Carl, you stepped it up.
I'm charging that.
So Julie, put one of both of those, like, put one in both files. Those
Got it.
manila folders.
Bless you.
There might be one extra. Oh, yeah, for Helen. I guess. So these two lots are situated in an R40 zoning district and are 15,000 square feet in size. Just going through the history of the parcel, you'll see that they were created pursuant to subdivision in 1910, and I included a copy of the subdivision map in your packet so you can see. That subdivision created lots that were small in size, and many of those lots survive to this day. The two lots in question have been owned in common ownership since 1933. They became non-conforming with the 1972 upzone from C-Res 15,000 to R40, and that's what it remains today. They have been owned since the, and I included a diagram. It might be easier for you to follow along. This is the single and separate search, and then if you look towards the back, there's sort of a color-coded.
This thing?
No, there's
No,
another
further,
thing.
okay.
It starts like this,
Oh, yeah.
because it's a little confusing because the ownership jumped around a bit through time. So in 33, there were
This will
all,
work for both?
sorry?
This works for both?
That works for both.
Okay, perfect.
So this actually shows 4 lots. And the reason it shows 4, because originally these were all 4 owned together. And you can see that the 4 of them sort of work part and parcel, all
Yep,
created
yep.
by that subdivision. So these 4 lots were owned by Annie Howell in 1933. In 1967, she sold all 4 of them. You can flip to the next page, to the Belltone Recording Corporation. In 1967, later that year, they were sold to Robert Sprout, who I'm guessing was a member of that corporation or a shareholder in that corporation. In 1968, they're still conforming under the law at this time. They were sold to the current family that owns them now. It was 2 brothers bought it with their wives, Simon Kirkpatrick, Margaret Karpatkin, Marvin Karpatkin, and Rhoda Karpatkin. In 1989, at this point, the ownership stayed like that through the upzoning in 72, became non-conforming in common ownership, the 4 of them. Because in 72, they became R40, the minimum lot size is 40,000 square feet. These are 15,000. In 1989, there was another shift in ownership. Simon and Margaret retained, what happened was Marvin passed away, and Simon and Margaret retained 16 and 12 Peconic, which are the subject lots here. Rhoda took 17 and 13 Dover, which are the companion lots to the west. And you can see the 2 colors there separating them. In 1989, later that year, they switched ownership again. Simon and Margaret retained the ownership of 16 and 12, and then Deborah Benjamin Karpakin, Ian Benjamin, Herbury Karpatrick, Amy Pestrich, Jeremy Karpakin, and Susan Karpakin, that's the next generation down, the cousins, took ownership of 17 and 13 Dover, not the subject parcels, the ones to the east, to the west. Then, in some years later, they sold these. I think this was in '89. They sold it. I don't see the date on there, unfortunately. To the North Sea Fire Department. That's 17 and 13 Dover, not the subject lots, but the companion lots. Were sold to the North Sea Fire District, where they remain today, owned by the Fire District. Simon and Margaret kept that until 2000, when it went to Rhonda Karpakin and the current owner. So this same family has owned it since the 60s. As you can see, they've switched ownership a lot of times, who owns what lots, and then ultimately they divested their ownership in the two lots on Dover and retained in Rhonda's name, finally, although it had been in Simon and Margaret's, and then the four of them before that, 16 and 12 Peconic. Today, their children, it's the estate of Rhonda, and their children are looking to clean up exactly what's been going on with this lot. If you look at that other colored page that I sent you, having known the history, you will see that all the lots identified by color are in the adjacent area are either pre-existing non-conforming in size, they're all smaller than 40,000 square feet. If they're in green, they're either the same size or smaller than the subject lots. If they're in red, they were actually granted area variances by this board. And we have a few right in the area. So at 8 Peconic, this board granted an area variance. And the reason this is relevant, we're not asking for an area variance, we're asking for single and separate. But it shows that this
These are
board,
wooded, right?
these are
vacant?
completely vacant. You can see.
Completely vacant wooded
Yeah.
properties.
Yeah.
So they have never been used, either in conjunction or separate. This board has sanctioned small lots in this area beyond what was pre-existing. So in 8 Peconic Bay, there was a avenue, there was a variance granted to permit a lot size of 11,250 square feet. At the time, 15,000 was required. That was back then. When it was 40,000 square feet minimum, this board granted a variance permitting one lot to be 18,950. That was 20 Peconic Bay Avenue, and another lot to actually be 11,050. So actually smaller than the lots before you today. I'm asking you to determine single and separate. Around the corner, another one was granted to allow a lot for 11,909 square feet. And I thought this was interesting in that variance. In the application upon which the variance was granted, the owner said, I bought this lot in 1968 intending to build on it or to sell it as a building lot, not realizing that my ownership of the adjoining house affects the zoning regulations. So the board then credited the fact that a lot of people are unaware of these merger provisions and how they work. So based on the history of approvals in this area, based on the lot size, the fact that so many lots are either this size or smaller in the adjacent area, they range in size. If you look down Dover, there's actually 2 lots that are 7,500 square feet. No, the little guys. Yeah, down.
This one here.
That one's really small. That got a variance for lot area. So both in the administrative history of approvals, both in the history of development, pre-existing nonconformities, and given the nature that this was owned by a single family in various configurations throughout, we are asking simply that you determine that these lots have been held in single and separate ownership.
Separate tax map numbers.
Separate tax map numbers.
bills.
The tax map has showed 2 lots, separate tax bills, tax map numbers. It's actually diverse ownership because now it's 4 or 5 cousins that own these lots.
And one hasn't been used to benefit the other.
Neither have been
Right.
used.
Exactly.
There was an interesting part, and I'm sure Katie and I have discussed it. There was a variance granted in 1987, I believe, that actually called for these 2 lots and then the neighboring 2 lots before the fire department bought them, to be used together is a single lot with a reduced building envelope. It was never acted upon. They never used it. They ended up selling it. But it's an interesting part. I think importantly that the board did consider reduced sizes as development back then, essentially an area variance.
But you're not asking for it.
We're not asking for that at all.
That's right.
I'm just showing the history.
Okay.
The other thing that's interesting is if it was determined to have merged in the 70s, then the sale to they would have merged with the fire department parcels as well. So the sale to the fire department would be completely messed up if there was determined to be merger. It's an official term.
You mentioned that and I got nervous.
Did you want to say something?
I was gonna ask about that. These lots were purchased in 1999, so my question was.
1980, I think it was
Well, I think it was, whenever it was, but if there was
By the fire.
common ownership at that time,
Right.
and they've been acquired by the fire district.
So in other words,
Understand
if
here.
you determined that they did merge and they weren't single
They all
separate,
would have
then-
merged.
Then we have issues with the fire department.
Exactly.
But that aside, can you just explain for me again the intent to merge piece? They discussed it and didn't execute, or?
There was the previous owner, and I say that the previous, the decedent.
Yep.
And I don't know the history of it because the children that I'm dealing with don't know now.
Right, okay.
Applied at one point to see if they could develop the 2 lots as a larger parcel, but never did it.
Okay.
They backed away from it, and they ended up selling one, a 2, and retaining the other 2.
So I mean, I think all the questions that John rattled off so quickly and eloquently in terms of single and separate suggests this is not an issue as far as I can tell. I don't know if anybody else has a different view of it.
No, you're
Yeah,
right.
And that was why I had called Carl yesterday, because I was like, usually the things that the board rattles off aren't all applicable here with the deed, and that's why I said to Carl, can you just give us a little more history on it then?
Which is helpful.
Yep.
No mortgages ever on the properties.
None right now that I'm aware of. I don't believe there are mortgages.
Okay.
I can't say
All right, so
forever.
for purposes, separate tax bills, that's what we
Absolutely.
usually rattle off.
Yep.
Yeah, it doesn't look like a problem to me. Is there anybody else on the board who wishes to comment? Is there anyone in the audience who wishes to comment on 12, what is this, 12 and 16 Peconic Bay Avenue? Is there anybody on Zoom who wishes to comment? Okay.
Thank you.
Julie, this is yours.
Yes, so we're going to close the public hearing, hold it open until September 20 for written comments with a final decision on 10-3.
Second.
Ms. Kay.
Aye.
Mr. Leonard.
Aye.
Mr. Macedonia.
Aye.
Mr. Beck.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Aye. Chair votes aye.
I'm sorry, and you made a motion to close them both, right?
Yes.
Yes.
Yeah.
Close both,
Yeah.
yes.
Thank you.
Talking to Carl.
Okay, number 6 on the agenda, Eric R. Giederman Irrevocable Trust and Diana K. Giederman, I'm sorry if I'm mispronouncing that, Irrevocable Trust, 1 Sandpiper Lane, East Quogue, Suffolk County Tax Map Number 900-343-1-5. Applicant requests relief of the following provisions of the Town Code to legalize a shed constructed without the benefit of a building permit. 1. 330-6 General Regulations that references 330-11 Residence District's Table of Dimensional Regulations for an accessory distance from street setback from 50 feet to 16.2 feet. And 2. 330-76D Placement of accessory building structures and uses in all districts. And Section 330-83C Yards to allow the shed to remain within the required front yard for the principal building and any other relief necessary.
The board has jurisdiction. I have the original. Can you pass those down?
Michael.
Yes.
So I don't need to swear you in, but please state your name and address.
Sure. Good evening, Madam Chairman, members of the board. Michael Semlensky, 860 Montauk Highway, Watermill, New York, for the applicant, the Geiderman family.
Giederman.
It's close enough.
I tried. I did my
I would
best.
correct you, but I may have it wrong as well. So I always
Let's call them the G's.
and they may even be OGs in this neighborhood because they've been there for a long time. So this shed's been in existence there since about 2008. It's a shed. It's a small shed that houses their garbage cans, and it's at the head of their driveway. I've handed out to you Unfortunately, Carl stole all the manila envelopes in our office, so you don't get envelopes. But I do have some pictures that go through. The first thing in the packet is a letter of support from the neighbor who would be most affected if the shed were to be built in a conforming location. It actually would be if it was in our backyard, it would be directly in their view shed out of their front yard. So in fact, when they were putting it up, they actually had conversations, as I said, when they were OGs in the neighborhood. These two families have both been in this neighborhood for a long period of time. If we were to place that there, it would be directly in their kind of in their view shed and you know and more bothersome to them than where it sits at the head of the driveway. This is a corner lot, and that's what requires the relief. It both has frontage on head of lots as well as Sandpiper. The second picture shows you it's from head of lots road. It's basically screened by the fencing. From Sandpiper Lane, it's visible through the trees and can be seen through the trees. But it's a modest structure that it has some outdoor equipment and some garbage cans. And then we just have an overhead of the neighborhood, so you can see. The neighboring parcel just to the south of this one does have a shed that's situated even closer to the property line at 5 feet. The granting this variance will not cause any undesirable change in character in the neighborhood. This shed's been there since 2008. It fits with the structure. It fits with the structure and the architectural design of the house. No changes are being proposed. This is actually just an as-built application. While we could feasibly change where this would be, the letter from the neighbor shows that would be an undesirable change in the neighborhood because it would be placing it closer to their property. It's not a burden to anyone driving by on head of lots because of the fencing and distance that are there. It's not a substantial variance. We're talking about 180 square foot. 180 square foot shed. It's no environmental impact here, and I think that's it. I can answer any questions if anyone has questions.
Helen, this is your application.
I came to visit the property, and I have no problem with this application. It's a very small shed.
I have a question about durability. You know, we usually ask, is the shed going to blow down during a bad storm? You know, we sometimes.
How long has it been there?
18 years. Well, since 2000. Yeah, since 2008.
Okay, so we can pretty much assume that's
not going to blow down. Big storms in between.
Yeah,
if it survives Sandy, it's gonna survive.
But you know, we do ask it, so.
Yeah, absolutely.
Yeah. Okay.
Maybe not have a storm that imperils it.
Right, from your mouth too. Yeah. Okay. Any questions from the board?
No.
Well, I would not be surprised that your neighbor immediately, conforming to the shed might not like it. But the thing that struck me, so I went around the whole neighborhood. There were people out walking, bike riding, and things like that. And it was last Sunday. It's the only shed visible in a driveway in the neighborhood. So, if it was a one-off and nobody ever came back and asked, I'd be less concerned. And there's a perfectly conforming location. I mean, most of the people coming in here tell us, I have this impossible condition. I'm trying to get a round peg in a square hole. And we don't have that problem here. And I get that everybody's used to it there and the homeowner's used to it there, but that's not the way the law is applied. So, it wouldn't take much to move the fence, lift it up, and put it in the backyard.
It would have to go all the way. It'd have to go all the way around the corner.
Next, it'd have to be 50 feet from the road.
What's that?
It'd have to be 50 feet from the street.
Correct.
So we put it right next to the pool.
It would put it probably directly in the middle, towards the middle of the house. And I would point out, if if I can show the overhead.
Well, it's also, what's the other setback? What's the other setback from the next door neighbor?
I'm just showing you the 50
So
feet
it's-
from
is
here.
it-
It's right here.
And what's the setback, 10?
10?
Right, it's an accessory structure, so it's
Correct.
10.
So it's 10, so is it,
I would point out when people are are walking by, properly walking by, they'd be walking on the west side of Sandpiper Lane. And in walking by the west side of Sandpiper Lane, you'll see that there's actually a little guardhouse, or what I think was originally designed to be a guardhouse that sits there. You actually would have to go by as well. So it's not out of the character for this neighborhood that you have a guardhouse that sits in that median, and then we're talking about something that's actually behind. This isn't at the front plane of the house. This is all the way at the back plane of the structure.
It's also used for garbage cans, is that correct?
Correct.
So the garbage
You need to get the
trucks
garbage
pull
out.
in there and they collect the garbage
Yeah.
from that.
Correct.
and it's also in the same design and style as the house, which I think is actually nice. I mean, I understand what you're saying, but I think it actually kind of looks cute to me.
I agree with you.
You know, it's kind of cute.
I will tell the board that we did try, because it does fit in, and it was when the structure, the primary structure was reshingled. This was shingled in accordance with that and in the same
Which is nice.
vernacular as that. Correct. I will also point out that we did consider making it part of the primary structure and somehow attaching it, but we found that would be too involved and would require further variance relief.
Is it sitting on top of the blacktop, or is it doesn't have a foundation?
I believe it's on a slab.
It's on a slab.
Yeah, it's a sturdy structure. It's been there since 2008.
Is there any way you can get the cost for putting it to a conforming location? We often ask that.
I can get an estimate.
Okay,
Sure.
I'd like to get that.
Yeah. Submit.
Okay. Okay, is there anybody else from the board who wishes to comment on this? Is there anyone in the audience who wishes to comment on 1 Sandpiper Lane? Is there anyone on Zoom who wishes to comment on 1 Sandpiper Lane? Okay, Helen, it's yours.
Yeah, I'll just do it by written. So.
Close the public hearing. We will open the written submission for September 20th with a decision on October 3rd.
Second.
Ms. Burgess?
Aye.
Mr. Leonard?
Aye.
Ms. Kane?
Aye.
Mr. Mascarenhas?
Aye.
Mr. Bevan?
Aye.
Mr. McDonald?
Aye.
Okay, thank you.
Great, thank you everyone. Have a good
Thank
night.
you.
Thank you.
Number 7 on the agenda, 1,115 Flying Point Road LLC, 1115 Flying Point Road, Watermill, Suffolk County Tax Map Number 900-178-2-13. Applicant requests relief from the following provisions of the Town Code for a proposed tennis court. 1, Section 330-6 General Regulations that references Section 330-11 Residence Districts Table of Dimensional Regulations for an accessory side yard setback of 20 feet where 30 feet is required. And 2, Section 330-76D, placement of accessory buildings, structures, and uses in all districts, and Section 330-83C yards to allow the tennis court to be located within the required minimum side yard for the principal building. In addition, applicant requests relief from Town Code Section 330-76C1 to allow a tennis court, pickleball court, and decks to be located on a lot that does not allow for the placement of a principal building and any other relief necessary.
Board has jurisdiction.
The applicant.
Would you like to introduce yourself?
Yes, my name is John Bennett, and I'm a lawyer at Bennett and Reed
Original business.
in Southampton.
1 second, John. We're just gonna
Yeah.
pass this. Okay, got something else? I mentioned to John today that I wanted him to kind of just explain this application to you, because I'm not sure that any of you have seen accessory structures without principal, or maybe you've seen
Well,
one.
I've read the law.
Oh,
I've read
that's
the-
good.
Okay.
Yes, thank you. I'm ready.
They're on you. They are on you.
To ask you questions.
3-minute rule.
Thank you.
Are on you.
We got the 3-minute rule, right?
That's good.
Aw. I think Katie trumped you on that. She asked for the explanation. He's already picking
All
on
right,
you.
John, give us a lesson.
Okay, so this is, my client is fortunate enough to own an oceanfront property that has a single-family residence on it and accessory structures, but they also own the adjacent parcel, which has nothing on it but a deck right now, and it has a certificate of occupancy for that deck because it's been around for a long time. So what we're trying to do here is put a tennis court and a pickleball court on this lot. They're both permitted. As a matter of fact, there's a building permit for both of them. So you're gonna say, what are we here for? And I'll explain it to you. I was involved in and the overarching goal of this code section is to promote people, have flexibility in land use regulations for people who own an adjacent lot. So it's really a density reduction law. That's why it's a good idea. I was involved in the public hearings on it. And the idea was, if you have an adjacent lot and it's controlled by the same people, you can put accessory structures on that adjacent lot without the benefit of a principal building envelope. So it encourages people to, in effect, reduce the density, because as of right on this lot, we could have a substantial single-family residence, a wastewater system, a pool, tennis court, et cetera, that would allow, but that would be very consistent with the development on Flying Point Road. But we have a vacant lot here, and what we want to do is put a tennis court on it and a pickleball court on it. And
Will you run into issues then with possibly merging them?
excuse me? No, you keep, the good thing about this law is that you can keep them separate.
One is owned in a corporation.
As long as they're controlled, the beneficial ownership is the same.
I have to go through that more carefully.
Okay.
So why don't you finish your presentation
Okay.
and ask some questions?
But wait, let me just
Well,
add there,
let
they're
me-
conforming lots, so they're not gonna merge.
Yeah, there's two conforming lots. Yeah,
Okay,
yeah.
but there's other requirements under the.
Well, yeah, I mean, I think you can ask for a covenant that says as long, these accessory structures can stay there as long as the lots are under common control.
What is the ownership of the two lots? Because I looked it up, it didn't look like they were the same LLC.
Oh, they're not the same LLC, they wouldn't be.
But it doesn't say similarly controlled.
I will represent to you that they are controlled by this, they have the same beneficial ownership and all.
Yeah, and I think the code does talk about, they don't have to be the exact same, they have to show some sort of common control.
Common ownership, yeah.
But think about the.
But I'd like to know what that common
should
ownership
be-
is. So let's, we can get
what
more
level of
specific
detail?
about, yeah.
Right.
Well,
What is the
I'll conform with the statute as it relates to beneficial ownership. I'm not asking for any relief for that. That's not part of your inquiry.
But John, it's a simple question. You're representing that there's a.
And I'm representing to you that the ownership is similarly beneficial to meet the requirements of the statute. And that's where your inquiry stops. I have to prove to the building department that the ownership of these lots, they're under the same control. So that's not part of it.
Otherwise, he'd be asking for a variance from that section. We see that every once in a while. If you want, if somebody wants to have an accessory apartment, but they don't have control of the corporation that's owning the house, then people have come to us and said, well, somebody owns 49%, and then we get into the ownership, but they're not asking for a variance from the ownership.
Okay, so the building department looks at the code, which says common ownership just
Yep.
refers to title held in the same names, title held by a married or registered domestic couple, and individuals holding title in one or more corporations.
That's right. The same beneficial
So you would
ownership.
then go to the, we're trying to learn here
Yeah.
what to do.
No, it's
So
good.
you
Yeah.
would go to the building department and you would
Proof.
say,
Right.
here's my proof of common ownership.
That's correct.
And they would then make the determination with advice from counsel, I
Sure.
assume.
That's exactly
As
right.
to whether that exists.
Whether you comply with the
Whether you
code.
comply with that, right.
But understand,
They
we're
deny
not.
it, and then you would wind up here.
Yeah, but
Correct.
understand, we're not here for
I
any
understand,
relief
but
as it
we-
relates to that.
But we're having an educational session.
Okay,
Remember,
good.
we were talking about
Okay.
that. So we're just trying to understand what the code says.
Very good.
And then just to.
And I will tell you that I have done subdivision work for many years, and what we do is something called, once we get the subdivision approved, we do something called checkerboarding, which is ABC Corporation, beneficially owned by all the same people, XYZ Corporation, beneficially owned by all the same people. The record ownership is not the same. But part of what the statute did, but the beneficial ownership is the same. And part of what the statute did was they realized that people, and again, this isn't a density reduction
I understand.
idea. they didn't want to force people to put them in the same record ownership, because God forbid, somebody's asleep at the wheel and somebody comes in and upzones the area, and then you have a merger. So that was the whole idea. A lot of thought went into this policy.
So going to the second point, which is if in fact the one owner sells the property,
Yes.
then you are required, and it goes to a different owner. So it's now no longer common
You
ownership.
have two options at that point.
Okay.
Okay. You have two options. You can, well, essentially what you have to do is, unless you can put a single-family residence
Right.
on it, you have
have
to
to
remove the
remove the
structures. You have to
structures.
remove the
Okay.
structures, yeah.
Okay.
And I'm glad we're talking about that, because the denial stated that, the denial is wrong in two aspects. One is that you have to show that there's no area on the lot for the placement of a principal building, and there is. It's small, it meets the minimum size requirements, it's ghosted in placeholder for single future family residence. I think maybe Art just missed it when he wrote the denial. But we were very particular about
You
putting
put
that
it
on
in
the
there.
survey.
I saw that, yes.
Number one. And number two, I think Art wrote the denial. And number two, he said that we don't meet the total side yard requirements, but we do. It's 50 on one side.
It's 71 total, right?
71 total. So we
yeah.
meet the minimum for the total side yard. So why are we here? There's a building permit to put these two structures on the property. So we don't need any relief for any use or anything like that. But what happens when you put them together? They're about 7 feet apart. So, so what we're here for is to ask the board to allow us, instead of holding, remember, this is the parcel that is owned and controlled by the same people. What we want to do is we want to put this tennis court 20 feet from this property that's under the same control, as opposed to 30 feet, a 10-foot request, so that you can have a reasonable transitional area between the two courts. Otherwise, they're 7 feet apart, and it's quite tight. It's not unusual that the board has considered something like this. One of the things I submitted in the my application, what I just submitted tonight, I handled a case some years ago. So I gave you two decisions on 395 Rose Hill Road. And at 395 Rose Hill Road, the gentleman, my client, had a house and wanted to put a tennis court in what is the rear yard, because it's a non-ocean front waterfront, which means the front yard is in essence the rear yard. So it was very tight. So we went, and this board gave us a variance, and then he started to put the tennis court in the front yard, and then he and she, I should say, lovely couple, really nice people. They started construction, and then they realized that the transitional space, the distance between the house and the tennis court was just too tight. So even though we had a variance already to put that tennis court there, we came back to this board and said, could you give us some additional relief so that we could get more space between the house and the tennis court in this front yard? And as in this case, there's all these environmental regulations that really reduce the allowable size of the property. And the court, and this board, said, yes, that's reasonable. So they, on the second go-around on 395 Rose Hill Road, they allowed us to increase the setback between the tennis court and the residence to 21 feet, which is why I chose the 21 feet in this instance. We want to create 21 feet of distance between the tennis court and the pickleball court. I think it's very reasonable, and there's no downside. And again, what you're doing is you're encouraging someone not to develop this lot for a separate single-family residence, and yet use it in conjunction, and all the impact that comes from that, parking, additional impact on services, et cetera, for a single-family residence as opposed to these accessory structures. So
What is the meaning of placeholder for future single-family residence?
When you go and ask for the building department to let you do this have these accessory structures on the adjacent lot that are similarly controlled. One of the things the statute says is that you have to demonstrate that you can put a single-family
single-family
residence
on
on
it.
it.
Or the structures have to be destroyed upon, the sale
Yes,
of the.
yes, yes.
I have a question. What about the neighbor on the other side?
Well, the
And it's
neighbor on the
not-
other side is, we're holding actually 20 feet more.
No, I know.
Oh, okay.
So, no, I'm saying for
Oh,
a property that's between two different owners, is there any requirement, you're saying, okay, so one of the adjacent owners is common ownership,
Mhm.
but the other one isn't. Is there a problem with that?
No, because the person who wants the benefit is the one that's controlling both parcels.
Okay. So that's
Typically,
not-
I can't speak for everybody, but one would think they'd prefer merely accessory structures next to them as opposed to a single-family residence. That's why, again, the whole idea was to encourage
Right,
people.
right.
I'm not saying that down the road, somebody might not be able to put a single-family residence there, but they'd have to take all this stuff
everything
out.
out,
So at
yeah.
least for a point in time, at a minimum, and maybe forever, I don't know. I'll give you a good example. I have a client that owns properties on, it's outside the town, but he owns the properties on Halsey Neck Lane. And it's an old house called Kuwaitan. It used to be owned by one of President Eisenhower's daughters. And there were a series of successors owners that had owned that property. And there are 3 lots. There's the main lot, and there are 2 lots on either side. And the board in the village allowed accessory structures to be on those lots on either side, even though they didn't have a principal structure. And it's been that way for 45 years. Because they keep them, never say never, they keep them separate so they could be separately saleable. But, people like the fact that that's a setup. So they have accessory structures on these lots that don't have principal structures.
It's the land on the other side of the
Right.
vacancy, that looks like it's under construction. Is it still that way?
No, it looks like it's finished.
Yeah,
I think it's
that might
finished.
be
And
an
it's
old.
heavily vegetated. I mean, it's.
It looks like a construction site. It doesn't look finished.
Yeah, I think it's finished. Yeah.
John, but your client owns the lot where the variance is being requested, right?
Yes.
Right,
So
no, that
let me
one,
ask you
I'm just
something,
wondering.
John,
Sure,
about-
yeah.
About the building department making
Right.
the determination about common ownership.
Mhm.
When this was written up,
Mhm.
they said
Mhm.
that you needed a variance for,
Where do they say?
it says, in addition, request relief from town code 76C1 to allow tennis court to be located on a lot that does not allow for the placement of a principal building. Does that mean that they've already determined
No.
that there's no common ownership?
No, they, oh,
So,
yeah,
all
it
right, I
must have
just
been.
wanted, because they put it in the write-up.
Listen, I thought it was confusing too. I called them this morning because I was like, "Do you own these? What it is?" And then I said, "Well, did you not show where the house is going to be?" Because I thought maybe they just were saying it's impossible, but the proposed
No,
house
I
is here.
understand.
Yeah, but
So, if he shows it on a survey that there is a possibility to put a principal house on there, he doesn't have to show common ownership?
No, he has to
No,
show both.
so-
All right,
Have to show
still
both.
do.
Have to show both.
But I'm asking because he wrote it up, like you've got to come to us for a
Yeah,
variance
he wrote it
on
up
that.
incorrectly.
I just want to clarify
There are
that.
two things that he missed.
Katie.
The more-
I just wanted to clarify that.
Oh, no, I understand, but again, I think the way that they wrote it up suggests that they didn't think there was room for a house, because they says on a lot that does not allow for the placement of a principal building. But I agree with you, the write-up was confusing, and we didn't see a typical Bennett and Reed writer either.
No, we didn't.
So I was looking for the writer.
Well, you know
I was
why?
like, there's gonna be a
Because I
story.
didn't I assumed that the building department had issued the,
The building permit already.
and had already,
Yes.
we passed that phase. That's probably why.
John, I've also had 2 board members ask me about, I know there's no wetlands on this property. Do you have a coastal erosion permit? I see it's got all the setbacks and everything on it.
Yeah, I'm outside of the coastal erosion hazard area, I'm behind
But that's
it.
what I'm saying, do you need a coastal
If I need
permit?
it, I'll get it.
Okay.
Yeah, I mean, if
But
I need it, I'll get
it
it.
complies, I saw
They-
it,
they-
it complies with the
I could be wrong,
setbacks.
but I think they've issued a building permit for this.
Yeah, you
Yeah.
said that, you said that.
I could be wrong, but regardless, if I need a coastal erosion permit,
Mhm.
you make the deal subject to that.
Right, but there's
You know.
no variances
No,
necessary.
no
from the
variance is
coastal erosion.
necessary. So how do you look at these things? And I follow the cases, some of which are my own recent cases, but, so there are 2 cases that I thought were very, very helpful on this. One is a case called 1430 Meadow Lane versus Village of Southampton Zoning Board of Appeals, which we just recently prevailed on. And in overturning a denial, Judge Modeleski, who's a very skilled zoning lawyer, he's a Supreme Court justice now, but he was the chairman of the Huntington Zoning Board of Appeals for 20 years, and he had a very active land use practice. He noted the following: zoning law is all about what the human senses experience. He's like a very scholarly guy. Zoning law is all about what the human senses experience as a result of the development and use of land. There's nothing in this record or in this written decision to establish that anyone other than the applicant gaining minimally expanded bedrooms with waterfront views would be able to recognize that area relief had been granted in this matter. The person driving down this road isn't going to see a difference between 10 feet. But let me just, if I may. Oh, I'm sorry. I shouldn't interrupt you. Yeah,
No,
I apologize.
let's wrap it.
Okay, and then there was another very, it's also a Modeleski case out of East Hampton, overturning a denial. And I think this is what everybody has to keep in mind. In upholding the constitutionality of zoning, the Supreme Court in Euclid said, so use your own as to not to harm another's. That's the essential tenet captured in the balancing test in 267B3B. There's no harm here. The benefit of the applicant, adequate transition between the tennis court and the pickleball court is the benefit sought, which is not outweighed by any detriment. No impact on the environment, arguably much less impact or any detriment to
What
either
about
property owner.
sound? That was my concern.
I can have them now. I meet the setback as it relates to the neighbor, and I'm imposing 10 feet less on my own property.
No, I understand that.
Yeah.
I understand that.
Yeah.
But it's still, a pickleball court is allowed. I've got a neighbor down my street
So
that I
the
don't.
pickleball court is totally complies.
Totally complies,
There's new regulations for pickleball courts.
which we
in the
comply
code.
with. 50-foot setback,
Yes.
we comply with that. Yeah.
Quick question.
Setback.
Yeah.
Sometimes if you're less, you have to sink it before feed and,
Right.
other kinds of
Yeah,
things.
yeah.
But I think one of the requirements that you should adhere to is the very heavy vegetation between the properties.
That's fine.
Is that
We're
That's what I was just
Vegetarian
I mean, I
saying.
however
think we need to put a stipulation of that.
That's fine. I
Yeah.
never argue
Certainly.
with reasonable
Okay, so I just want to
vegetative
say,
buffer.
I went to the property, it's beautiful, it's covered with all sorts of native plantains, it's really quite lovely, which will be gone. There is a cabana that's right up high on a dune, that was approved, and that's been there for a while.
That's
as you
been there
said.
forever. It has a CO.
Yeah, I know, it has a CO, it's like really,
It's been
right up on a dune.
It's been in this family since the prior family since 1947.
Right, so,
And
see if I
fully
have any other
certificated.
questions. All right, so we're talking about,
But to your point, John, the sound, I'm imposing the reduced setback on my
No,
own
I
property,
understand
and
that,
we're
but
conforming totally.
I think the chairperson made my point, that I think there should be screening, although
That's fine.
we were just looking at your client's two properties and or the beneficial owner's two properties. The one next door on the other side of the pickleball court appears to be not, and you can confirm that because you've been to the property, Susan, it's in construction. So we don't even know who's there yet. It doesn't have a C of O. So
it looks like it's pretty well done, I don't know.
it doesn't have a driveway. It's a construction zone. There's trucks.
When was that taken?
What?
When was that picture taken?
No, but Anthony just looked it up.
Oh.
There's no C of O.
So
Okay.
So it's a
But
construction.
be that as it may, I mean, I think we still have to protect
We
that
still have to
neighbor,
protect it. That's
whether
exactly.
he is, exists right now or not. I mean, so.
You have to assume there's going to be a house there. I agree. Yeah.
Oh, absolutely. And we can't say,
Well, it
oh,
is-
well, the
it's-
neighbor has no
Well, and
complaint
under
because there's no
construction.
neighbor at this point.
I have one
Go ahead,
question.
go ahead.
Yes.
Do you anticipate night lights or evening lights or some other light plan eventually? Is that?
There's no night lights allowed.
Well,
No,
I
you can't
understand
allow
that,
those.
but I just want to be sure.
I'm going to have them. I'm not asking for any relief, so can't have them.
And just so that you know, sound travels a lot more at the ocean with the wide open, So given the pickleball court issue.
Pickleball courts are loud.
Yeah, it's very loud.
But they're permitted.
But the
They're
pickleball
permitted,
court
yes,
is not
but
part of
they're
our
loud.
variance discussion, so. I just-
No, it's not. It's
It's
the
not.
tennis court.
It's
The
not.
pickleball court meets the enhanced 50-foot
Yes.
setback.
It does,
So it does.
even though it's probably going to be very noisy. Okay.
I worked on that pickleball law.
I know
You
the law is a
did.
good one,
This
but
is what
you know.
the town board said
You know what's
is
interesting?
appropriate.
Doug DeGroot tells me that pickleball and padel, in terms of noise, are two different things.
I just thought the guy couldn't scout. You know,
Oh,
you
yeah, I
see
know.
Padel built, you
Oh,
know, it's
I
like,
know,
yeah, it
yeah.
looks like, they do
It's like
say
an
there's a
alley.
new racket, that's
Yeah.
apparently. Anybody else from the board who wishes to be heard on this matter?
Nope.
Okay, is there anyone in the audience who wishes to be heard on 1115 Flying Point Road? Is there anybody on Zoom who wishes to be heard? Okay, this is mine. Okay. All right, so given that, you understand that we're gonna do something with vegetation.
That's fine, never a problem.
You are going to submit a coastal erosion request if
If
necessary.
necessary, yes.
If necessary, and any other, things, then we're going to close the public hearing. We're going to keep it open for written comments until, September 20th, with a decision on October 3rd.
Second.
You know, before, you know how people used to get around this? They would just put a small, single-family residence on the lot. So
made
you have
that
the
point.
septic system and all that.
Yeah, you made the point, yeah.
So this is actually a much better way of going about these things.
Okay. Mr. Leonard.
Aye.
Ms. King.
Aye.
Ms. Macedonia.
Aye.
Mr. Redmond.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess.
I,
Chair votes aye.
Thanks,
Okay,
everyone.
Thank you.
Do I read the description and
Enjoy the week
re-advertise?
coming up. It's like the best time of
Katie,
year.
do I
Yes.
read the re-advertised description?
Yes.
No, I do.
Yes, for Frank DiMaria? Yes.
Yeah, okay. Okay, number 8 on the agenda, Frank DiMaria and Geraldine DiMaria, 5 Harris Lane, North Sea, Suffolk County Tax Map Number 900-77-1-13. Applicant requests relief from the following provisions of the Town Code for proposed outdoor kitchen. 1, Section 330-6, General Regulations that references 330-11, Residence District's Table of Dimensional Regulations for an accessory distance from street setback front yard from 70 feet to 35 feet from the easterly property line, North Sea Road, and 2, Section 330-76D, placement of accessory building structures and uses in all districts, and 330-83C yards to allow the outdoor kitchen to be located within the required front yard for the principal building on a non-conforming lot and any other relief necessary.
The board has jurisdiction. Can you pass that to John Leonard?
Just give me a minute.
John.
And then you
Right,
use
right
that
papers out.
original.
This goes to John?
Yes.
Yep.
John.
Thank you.
Sorry. There you go.
Are you an attorney?
No, I'm not.
Oh.
I'm representing myself.
Okay, good. Then I'm just going to swear you in.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Please state your name and address.
My name is Frank DiMaria. My address is 3063 Ratcliffe Drive, Yorktown Heights, New York. My wife and I, we own this property since 2014. This is basically a weekend residence for us. And I'm here to request a relief for putting an outdoor kitchen behind the main structure building. And it needs to be set, 70 feet from the road, but there's not enough room for that. It's directly behind my residence. There's a deck there now. It's right adjacent to the deck, so it's off the building. It's 12 feet. It's a small. It's basically it's outdoor kitchen, but it's a counter. It's 36-inch high counter, U-shape, 13 feet by 13 feet by 13 feet. No roof, anything. It's just a counter with a grill, barbecue. That's it.
Refrigerator.
Yeah, it's simple. I provided these pictures of the yard because there's trees. There's like a double set of trees along the road. There's privets about 7 foot high. Can't see it from the road. And then there's another row of trees which are about 20 feet high. Next to the deck and behind the house. And there's really no other spot to put it in the yard. So that's why I'm here.
These pictures were taken when it was foggy.
Yeah.
Yes. I was supposed to be here in August, and
What a foggy, I mean,
yeah.
it's amazing, yeah. But I can see what you're saying about heavily vegetated.
These trees are staying, right?
Heavily
Yes,
vegetated.
yes, everything's staying there.
John, go
Yeah,
ahead.
the property's burdened with 2 front yards.
Right.
I don't see putting it in the vicinity of the Harris Lane side. It makes no sense. It's not the backyard.
No.
Right.
It's the functional front yard is
Yes,
Harris Lane.
yes.
I have no problem with this application.
Anybody else want to comment? I have no problem with it
Okay,
either.
good.
It's heavily vegetated as long as you maintain the vegetation.
Yes, yes,
it will
that's all.
be.
I do.
Yeah. But it's just in the most, I think it's in the most, makes more sense area.
Exactly.
Anybody else?
I'm good.
Okay, is anybody in the audience wish to be heard on 5 Harris Lane? Anybody on Zoom who wishes to be heard on 5 Harris Lane? Okay, John, this is yours.
Okay, I move to close the public hearing on this application, hold it open for written submissions to September 20th with a written decision by October 3rd.
Second.
Mr. Leonard.
Aye.
Ms. Kane.
Aye.
Mr. Mastonia.
Aye.
Mr. Redmond.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Chair votes aye. Okay, thank you very much.
Thank you.
Okay, number 9 on the agenda, application of Anthony Bartolomeo, 15 Hampton Road, Hampton Bays, Suffolk County Tax Map number 900-294-2-10.
Just give me a second. Of course. Okay, are you an attorney? Okay, let me swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name and address.
Anthony Bartolomeo, 15 Hampton Road, Hampton Bays.
Okay, Mr. Barkerman. And Heather, do you want to just make your announcement?
Sure. Heather Wright for the applicant, 48H Main Street, Leonard Hampton Beach.
All the way down.
Okay, all right, this goes to, sorry, we're just doing some housekeeping here. This goes to John.
John?
Yes.
Okay. Okay, Heather, do you want to tell us about the application?
Sure. So, this application is a bit challenging. The property itself is a bit challenging. I wanted to give you a little bit of background on this. So my clients own the property since the 90s. You know, I want to start with the pool. When he purchased the home, the pool was in place, and there was a CO for the pool. And it's been in that location since he purchased the property in the 90s. And it wasn't until, I guess, 2021, 2022, when the neighbor put their property for sale and had a contract and got a survey of their property, that it was discovered we had this issue with the pool, which took quite a long time to resolve. And it's really an unfortunate situation because, you know, my client has had this property for so long, and really, I gave you the aerials because it really does show you, there's a 2021 aerial and then there's the current aerial. It really does show you that the property, at least my clients had thought that the property where the fence has been located all that time was actually his property. So after a long process and some litigation, there was a boundary line easement that was entered into between my client and the seller of the property. The property was sold, and now there's a new owner who is subject to that easement, which allows the small pool encroachment to remain and the fence to remain in its current location. So that was the first issue that we discovered. And then because of this issue, it came to light that my client did construct the deck and the roof over that deck in 2020. I guess it was during COVID, and we did so without permits. So we're here to address a number of issues for the board. Most important is cleaning up the issue with the pool. Again, has a valid CO and an intervening CO from the town dated February of 2025 for an addition, and that addition application included a survey to the building department which shows the current configuration of the pool.
It wasn't 2025, it was 20.
I'm sorry, 2005.
Okay, thank you.
Yes, 2005.
Who's in the future?
Yeah, in the future.
Next year.
So, we're here to request the variances to allow, to allow the pool to remain in its current location and to legalize the roofed over wood deck. We need pyramid relief for the wood deck as well as side yard relief of 3.5 feet from the sideline. Again, I think it's a unique application in that the lot essentially functions larger than it actually is because of the fence location and now because of the easement agreement between the two lots. My client has spoken to the new owner, neighbor, and who's aware of the application and understands what we're asking for. We have a letter or an email in support from the neighbor on the other side about, in support of the application. And because of the way the lot functions, and I actually have a copy of the neighbor's survey too. Neighbor's currently doing some work, I guess, and applied for a permit. And you can see on their survey, it shows the property line and then the configuration of the fence and how it impacts their line. Essentially, this lot is it's operating bigger than it actually is. So we don't believe it will have a negative impact on the character of the neighborhood. This roofed deck is situated south of the neighbor's home, so it's not right next to the neighbor. It's not really visible. It's further south here, while it is substantial, I think the boundary line agreement is a unique situation and kind of mitigates that substantiality because for over 30 years, my client was under the misassumption that he owned more property than he did.
When was the pool put in?
The pool was actually in the late 80s because I pulled the application, but it was not CO'd until 1994. So it looks like the pool, the final inspection for the pool was 6/14/90, and the CO is 12/28/94.
Okay, and the wood deck?
The wood was installed
2020.
2020.
2020.
I have a question. Sure. I have two questions. John, did you want to take you're the lead on this. Do you want to ask the questions first?
No, you can.
Okay.
You go
So
ahead.
my question is, hypothetically, if the neighbor, what is the neighbor's property line? I mean, if the neighbor came in to us and said, we want a variance, a setback variance for putting something in the backyard, where do they measure it from?
The actual property
Their
line.
actual property line.
Not the
Okay,
easement.
not the
No.
easement. Okay.
No, because the boundary line agreement.
Okay, so it's
Which
the
is not
property
recorded as
still is
Yes.
the property line, the original,
Correct.
for the other neighbor.
And we did explore a lot line modification. We explored a lot of different ways to solve this problem.
Yeah.
The problem is our lot is a conforming lot, but the adjacent lot is not.
Yeah.
And so it would have created two non-conforming, we looked at this every which way.
It
to
would
try
have
to solve-
created an increasing nonconformity.
So,
Correct.
So I have another question. If in fact you decided at some point you didn't like where the pool was, you wanted to move everything, it gets rid of the variance then, is that correct? In other words, if you were to replace, what happens if the existing pool and fence are removed for some reason? What happens? Does the boundary line permit agreement still in effect?
The boundary.
because you still have the fence.
No, but so
Yeah.
they
You
get
have
rid of
an
the fence.
easement.
They get rid of the pool and the fence.
If
Because
they
they
know
don't
the
need-
pool and the fence, then you would probably, want to get rid of the boundary line agreement and
Right.
get
Well,
rid
and
of
I-
the.
and-
I'm
well,
just asking.
If
Yeah.
we get rid of the pool and the fence someday in the future, we would have to, if we were gonna get a new pool, apply to the building department for a new pool. And the building department would require us to meet the setbacks.
But would that negate the boundary line?
You would need to vacate it.
Yeah, no, it does not
Okay,
negate
okay.
the boundary
That's what I was
agreement.
just
Because it's an easement, not just a
Yeah,
boundary line
exactly.
agreement.
It's filed with the county clerk.
Setbacks to the property line, not the boundary agreement.
Correct.
Okay. Anybody have any questions?
No.
It sounds like some sort of inadvertent kind of
Yeah.
confusion that, and you seem to have worked it out with the neighbor, which is very honorable and probably was difficult. But yeah, no, I
Yeah,
appreciate that.
It's my application. I have no issue with it. I can't imagine forcing you to rip out your pool that you've had in since the 80s or the 90s. That's insane.
Right. Anybody else from the board wishes to comment? Is there anyone in the audience who wishes to be heard on 15 Hampton Road? Is there anyone on Zoom who wishes to be heard on 15 Hampton Road? All right, John, this is yours.
Okay, I move to close the public hearing on this application, hold it open for written submissions for September 20th and a decision on October 3rd.
Is there a second?
Second.
Mr. Leonard?
Aye.
Ms. Kane?
Aye.
Mr. Mascaro?
Aye.
Mr. Rathbun?
Aye.
Mr. McDonald?
Aye.
Ms. Burgess?
Thank you very much.
Thank you very much.
Okay, number 11 on the agenda, the application of Joseph G. Wagner III Irrevocable Trust, 13 Lakeview Court, Eastport, Suffolk County Tax Map Number 900-349-1-16.2.
Anybody here? Anybody on Zoom?
Bueller.
Peter, is there anyone on Zoom for this application?
Not for this one.
No, it's not Carl's.
Dennis?
No.
Hey,
Just
no.
second call it. It was
We'll
that.
second
David
call.
Fox, maybe?
That's
No,
the
that's
surveyor.
Oh, that's a surveyor, sorry.
Okay,
Just
let's
second
move
call.
on.
We'll second call this one.
Number 12 is withdrawn. Okay.
13 is Carl.
Number 13 on the agenda, application of Roger and Jennifer Morales, 308 Sagaponack Road, Bridgehampton, Suffolk County Tax Map Number 900-89-1-5. You're up.
Good evening again.
Good evening.
So,
You want to state your name, please?
sure, Carl Benincasa, 860 Montauk Highway, Watermill, New York, for the applicant. When we were last here, there were some requests made by the board. Survey updates in specifically that the survey was revised to reflect the removal of the barbecue and include the information as requested by the board, namely a 10-foot setback from the pool equipment to the western property line, and then the 4-foot setback from the outdoor shower to the western property line. As you may recall, in addition, there was a neighbor here who appeared in opposition. He is essentially the only affected neighbor, the neighbor directly to the east of this property. Actually, on Mr. McDonald's suggestion, is the one that won the day, they agreed to fence the HVAC area with stockade fence and the pool equipment with stockade fence, and he has withdrawn his opposition. That fencing is scheduled to go in I think it's September 16th was the date. And you can certainly, if you were to grant this variance, you can certainly make that a condition of the variance. So thank you.
Okay.
Do we have the copy of the new survey?
Yes, it was submitted.
It was, it was.
I have another one if you need it.
No landscaping requirements?
No, he just wanted the fencing. If you want buffering, we certainly will
the
do that.
neighbor.
Well, I think
Just
we
hold the
do
fence.
want to, make sure that there's buffering,
Sure.
for sure.
It was hard to access, but I was able to be almost on the property to the adjacent neighbor who was the one who was here. Very dense property line vegetation.
Very
I couldn't see it all the way through, but, if you were talking, which is a useful thing to do, and you got the accommodation for the fence, I'm assuming the screening is presumptively adequate?
Well, if you want us to maintain what's there,
I think we
sure.
should say
Yeah.
That's no
I
problem.
mean, this is so close to the property line.
It
We
is.
need to, we need to
sorry?
put in
Oh,
some
yeah,
kind
sure,
of a
yeah.
stipulation.
Happy to do that. We also had, you had asked us to reach out to contractors. We've got a few quotes.
Yeah.
Bolgen and Associates, it was $34,000 to relocate. We had another quote from Plum Builders for $22,000. So somewhere in the middle there is probably where the cost would be.
Can I make one more request?
Sure.
Dark sky lighting for any of the hot tub, shower area. I have no idea if this is a home that people are gonna live in, or is it an Airbnb for 10 weeks a year that just happened to be like June through September, right? So, considering that it's a 5-foot setback, which is a greater distance than you and I are sitting.
Yes.
I'm sorry, less distance than you and I are sitting. Some extra effort to mitigate all that is appreciated.
Absolutely.
So in other words, we could also stipulate there's be no lighting that wouldn't reflect on a neighbor's property, would have to be
I
only
think
when it's-
dark sky is compliant.
Yeah,
Alright,
It
so-
covers that.
That would be good.
It's already governed by that, but if you want
Why
to
does
add,
it make a
add that,
recognition of it
absolutely.
in the decision?
That way somebody doesn't have to say, hey, I'm grandfather, don't bother me.
Yeah,
Right.
yeah.
absolutely.
Yeah,
No, that's
okay.
not going to be a problem.
Okay.
All right,
Good point.
anybody
I like
else?
that.
Thoughts, comments?
Carl, do we have the cost estimates to remove? Did you submit those?
Yeah,
she did.
I just know.
Yeah,
just-
I have the
Stamped
written
it?
estimates.
You haven't submitted them, but you
I have,
should.
so one's in an email and the other is
That's
an
okay.
actual
Okay.
estimate. I'll give you the actual estimate.
See if there's anybody.
I'm good with it.
Okay.
Now it's moving pool equipment.
That's to
Have you put that in
relocate the
file?
pool and the shower.
Right.
Not the pool, I'm sorry, the spa
And the shower.
and the shower.
What's the estimate amount?
30, what was it on that?
22.
34 and 22.
That's funny, and sometimes to move a shed, it's $150,000.
Really? We'll go with that.
Obviously, you
We've
use
seen
the
the
contact.
craziest stuff.
I got a discount, I guess.
Yeah, I guess.
Okay, so is there anyone in the audience who wishes to be heard on this application? Of 308 Sagaponack Road? Is there anyone on Zoom who wishes to be heard on this application? Okay,
So let's.
Wait, no, there's somebody on Zoom.
wait, somebody's on
Oh,
Zoom.
sorry.
Could be that big.
Could be a neighbor.
Oh, no.
They are muted.
Can you hear me?
We can hear you, can't see you.
See you.
I don't know why, I'm Pamela Harwood.
Okay, I'd have to swear you in, Pamela, before you make a comment. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name and address.
My name is Pamela Harwood. Address is 371 Woodland Drive in Bridgehampton, and I'm representing the Bridgehampton Civic Association. Don't know why you can't see my video, because I've enabled it all. I did not have the benefit of being on the first, public hearing for this, but this did come to my attention, for this evening. And I found it quite shocking, that the owner has built a spa, without the benefit of a building permit, 7 feet away from the property line versus the 30 feet required, an outdoor shower without a building permit, in addition to the house without a building permit, and it sounds, the feeling I'm getting from the board this evening is that this might be a done deal with a bit of fencing and vegetation, and I find it disturbing, and the Bridgehampton Civic, has been very consistent in opposing these sort of things where circumventing town code seems to be becoming normalized. Like people building without permit, then coming to the ZBA for a variance because it's already built and it would be expensive to remove. So, okay, you could keep it and put the fence and some vegetation and it's okay. I can tell you on my property, in Bridgehampton, that there is a pool next door to me that is completely legal with the required setbacks, and they have a fence, dense vegetation on their side, and I have dense vegetation on my side. I can hear every word they're saying at that pool. So the idea that fences and vegetation stop noise from a spa or structures and people being that close, I think is myth. And it just disturbs me that this is all becoming very normalized. So if someone wants to override town code, you just build it anyway and go to the ZBA for a variance and you get it. And this is quite disturbing, and we quite frankly object to this.
Thank you.
There is a C of O for the garage, the cottage, the shed, the swimming pool. That was
Yes,
issued
but
in
not the spa,
2019.
the outdoor shower, and in addition to the main building, which were the items on the agenda tonight.
Carl, could you remind us when they were all built?
Well before my client took ownership, The addition,
But they bought it.
am I speaking or are you speaking?
No, Carl, go ahead.
Just a moment, Ms. Harwood, please.
Well, before my client took ownership, we were aware of these issues before we took ownership and are here voluntarily to legalize them. The exact date that these things were done, the extension to the home was done in the 60s. It's here because for some reason, even though permits were issued, an updated CO was issued with that there. They doubled back and realized that, in fact, this had never been approved, this extension, which requires a slight variance and is an extension of a pre-existing nonconformity because there are two cottages, two dwellings, and that's why we needed that relief
Right,
for
and
that.
I would also note that the spa is, the relief being requested on the spa is 3 feet.
Yes.
The barbecue was removed at the request of the board.
Yes, thank you.
And while the shower is 3.7 feet, I don't think a shower really does generate that much noise. And if so, for a very short period of time. And so that was the thinking of the board in making the requests with regard to this application.
Ms. Harwood, I have a question for you because you seem to be suggesting that there was something intentional in the building to have it be an as-built issue, thereby circumventing zoning requirements and getting relief. Is there any evidence of that? Or is it just sort of what you're gathering?
I'm not speaking about this particular property, and that was the intent of the property owners to build these structures in this case. I'm pointing to an overall increasing trend in the town where this is a trend, and variances to be given, they not always the variances being requested, it may be, well, we'll give you a little less than you're asking, but we'll give you something.
Right. Can I just stop you there? Because I think if there's reason for this board to believe that that's occurring, we ought to be mindful of it. But I don't think for this matter, there's any evidence that that's occurred. So I feel like it's a little bit of a red herring.
Well, I have to say I may misread the agenda incorrectly, but it said the spa, they're requesting a 7-foot setback where 30 feet is required. So now you're only saying there's a 3-foot difference, so maybe I'm misunderstanding.
Is that,
something.
did I make that mistake? Is 30 feet required?
It's an accessory structure.
It's an accessory structure.
It's accessory, so it's 10.
It's 10.
Well, the agenda says 7 feet.
No,
being
accessory
requested where
structure
30
is one.
feet is required.
What zone is this in? R80? Accessory structures do require.
Oh, it's
setback.
R80.
Oh, okay.
It might be 20.
It's 30. Well, thank you very much for your comments. We'll take a
Also, by
minute.
the way, the outdoor shower on the agenda, it says that it's 3.7 feet away from the setback versus the 30 feet that's required. So that's why I thought.
Understood, Ms. Harwood, but I would just say to you that I think that we have to take these things in context, and that's what this board does on a regular basis. Not every application is equal. And so given what it is, what the accessory structure is a completely different thing in this application than in other applications. We're talking about a shower and a spa. They're not going to be used on a 24-hour basis. It's not like we're putting a pickleball court, which is very loud, very close to the property line. And I think that there's has to be a spirit of compromise in these deliberations. And that's all that I would say.
And I believe that there has to be a spirit of trying to build according to the code and to ask for building permits and to do everything legally. And for the zoning board of appeals to sometimes ask people to take things down that were done illegally.
And we do.
Put them in a place where they will be legal. And on such kind of road I go, these are not insignificantly sized
Right.
properties. And I've yet to hear, and I could be wrong about this, but I've yet to hear anyone say, well, rip it up. It's not in the right, it's really not in the right place. And I don't see where the hardship is at. And again, I'm mentioning this because it's part of a very frequently requested thing
Understood.
Lots of people going to.
If I may, just a moment, ma'am. I understand that, ma'am. Hold on, one moment. But also, we have to take into consideration, is there a complaint with regard to these things? That we're requiring vegetation, there's a next door neighbor who, if they objected to it, could certainly come to us and say that they object to it.
And they did.
They did.
And we compromised in order to,
It was the board's suggestion that the neighbor
Yes.
appreciated.
and the neighbor was fine with the changes that we made, which was removing the barbecue. So,
Okay, we're gonna have to move on. All right, Ms.
3 minutes is up.
Harwood, we're gonna have to move on. There seems to be something.
One more thing I believe the chair earlier said on another application, that should it be the neighbors who decide whether or not something
There's
that's
someone
not
else.
code should be allowed? Or is it town code that should determine?
Oh, yeah, it's the rest of
Thank you
them.
very much.
See, they're coming out.
Thank you.
Okay, thank you
Yeah,
for
they're
your
around
comments.
everybody,
Is there anybody else on Zoom who wishes to be heard?
We do have someone else.
Okay, go ahead.
Hi, I'm Meredith Berkowitz. I am an attorney. I reside at 140 Bay, Bridgehampton, New York.
Okay.
So I'm also a member of the Bridgehampton Civic Association, and I was actually on the first hearing and did listen to those, the original comments that went on. I want to add a couple of things. One, I'm going to quote Justice Cardozo, who was actually on the New York State Court of Appeals in 1925 when zoning regulations were adopted in the state of New York. The creation of a board of appeals with discretionary powers to meet specific cases of hardship or specific instances of improper classification is not to destroy zoning as a policy, but to save it. The quote should not be taken to mean that the boards of appeals have a blank check to relieve every hardship caused by zoning ordinances or local laws. Great care must be taken to ensure that the purpose and intent of the ordinance or local laws carried out, lest too many changes without proper foundation destroy the zoning itself. And so what Pamela's point is that she was saying, is that that's what's happened. When you grant a variance here, sometimes it destroys the zoning of the code itself. And that has to be a consideration that this board takes into account. Yes, in this case, and you have to look at each case individually, but you have a 5-part balancing test. And maybe this neighbor agreed to it, great. But there is a community interest in seeing that the zoning code is upheld and enforced by the zoning board of appeals and not just simply overridden by the zoning board of appeals. That is a legislative function that the zoning board should not be usurping from the legislative arm of the town's municipal government.
I'm sorry, hold on a moment. That completely mischaracterizes the entire purpose of the Zoning Board of Appeals, which is to Justice Cardozo or not, Justice Cardozo or not, that completely denies our purpose here, which is to grant a variance where appropriate and in the most.
That's actually not the purpose of the zoning board. It is not.
Yes, it is.
Where appropriate, it is to. No, it is not. It is to uphold and grant relief where necessary.
What's the difference between where necessary and as appropriate?
An area variance, that is the test, and courts have upheld it for hundreds of years. Somehow this board has been convinced that that is not the law, and I can tell you that I saw that often with the prior zoning board that was under Adam Grossman's leadership, where he doesn't understand the law, or didn't understand the law.
All right, that's
enough.
stop the
No.
conversation now.
Next.
Exceeded the 3 minutes.
No.
And we've been pretty generous in giving you guys a lot of opportunity to talk. I think we understand your point. I think we do take our position seriously, and we do try to make some, balanced judgments. Wait, let me finish. Let me finish, Ms. Berkowitz. Let me finish. We're trying to balance a lot of different things, and we do the best that we can. And we appreciate the fact that, you tried to hold our feet to the fire, and I welcome it. So thank you very much.
I would like to say I appreciate that. I know it's not an easy job, but the concern is that it's not just about this neighbor, to Mr. Leonard's point, but the fact that if you grant a variance that's 5 feet where 30 feet is required, or 3.5 where 30 feet is required, you're setting the precedent. And the next set of attorneys are going to come in and say the same thing. Well, I also want 5 feet.
Well, but honestly, we have dealt with that in the past, and we look at every application de novo.
Right,
And we consider it on the basis of the facts.
And if you have watched our meetings in the past, you will note that very frequently, we have discussed how our actions here in this chamber affect the precedent that we set going forward in terms of public opinion and public requests for variances. We have been very clear, especially with regard to pyramid height, setbacks, that we are not looking to open the door to a plethora of applications that are the same thing. However, in certain instances, like the one we have here, we recognize that there are compromises that need to be made. And this, in my opinion, this application passes the 5-part test. This application is not going to change the character of the neighborhood, and this application, if granted, is not going to change the way that I would vote on any other application and just grant everybody everything that they want. And I think
Thank
we've
you
been
very
very
much,
conscious
John.
of that.
Okay, thank you, Ms. Berkowitz.
Thank you.
Is there any other comments from the board?
No.
Anybody else on Zoom?
So
Okay.
I'm gonna make a motion.
All right, wait.
Yeah.
Do
Well,
you
let me
wanna
just
say
add to the
something?
record, because I think we can offer this, bolster this a bit.
Of course.
There are what was not discussed is that there are pre-existing non-conforming structures on this lot that exist with a certificate of occupancy 4 feet from the side yard. So this is not, this is not increasing any non-conformity, which is certainly relevant when considering these applications. This is not out of the blue. The other thing that should be noted for the record is that there are wetlands noted within 162 feet and 200 feet east. To move this spot any degree to the west would put it within wetlands jurisdiction. And there are certainly overarching concerns there. So I think in the context of what was previously stated on the record, and I do stand corrected, it's been a while since I first presented this, it was a 30 feet. But
That was
in
my
the
mistake as
context
well.
of an existing structure that exists approved 4 feet. So I think all of that mitigates the severity of the relief, which is certainly one of the 5-part tests. And I think that's the one that they're helping on.
And also its precedential value.
Okay.
Yes,
Thank
exactly.
you, Carl, for adding that to the record.
Sure.
Kevin, this is yours.
Okay, thank you. So I'm gonna move that we close the hearing, receive comments until 9:20. Comments are welcome from anybody who wants to make an additional comment to the board to consider, and then a decision slated for 10:3.
Second.
Mr. McDonald?
Aye.
Mr. Leonard?
Aye.
Ms. Kane?
Aye.
Mr. Mastonio?
Aye.
Mr. Brennan?
Aye.
Ms. Burgess?
Aye.
Chair votes aye. Thank you, Carl.
Thank you.
Okay, number 14 on the agenda, the application of Patrick Gordon and Zach Robbins, 494 North Main Street, North C, Suffolk County Tax Map number 900-132-2-5.2.
Okay, we sworn you in, right? Okay. So just state your name again. Sure.
Zach
John
Robbins.
Leonard?
Yep.
All right, Zach Robbins and Heather, do you want to just say?
Sure, Heather Wright.
John.
Sorry.
Thank you. John.
Good evening, Heather Wright for the applicant, 48H Main Street, West Hampton Beach. Okay, so it's been 2 months since we were here last on this application. The board had asked for a couple things from the applicant and asked us to do a little research and come back, which I believe we did. You should all have the presentation that I distributed. You should have had it electronically, but I wanted you to have oh no?
We haven't,
Electronically?
it's been a little bit because Candace is.
Okay, I'm sorry. I apologize. We had emailed it to Candace, but I understand. So I brought copies.
Okay.
We're good.
So it was this.
Yes.
Okay,
yes,
perfect.
Okay. So a couple things then.
And thank you for this.
Sure. Yeah, so you asked us at the last hearing for additional information regarding the history of this property and some background on it. So specifically, you were looking for sort of a timeline of the property history and the COs on this property and the use. Documentation from a contractor regarding the cost to decommission that third floor space. And then I believe you would ask for photographs of what the space looked like. So we provided photographs of what it looks like now. We provided photographs from when it was listed. And so I just want to go over a couple things with you. So And we also have 2 letters indicating that that finished third floor has been in existence since the early 80s, and those letters are also included in your package. And you know, at the last hearing, I did provide you with opinions from 2 real estate brokers regarding the value of that the value of the home with that finished space. And, you know, we talked a little bit about the prior decisions of this board where the board granted variances for third floor spaces. And so just to refresh your memory here, my clients purchased this property in 2021. Yes, they were represented by counsel when they purchased the home. They believed that the third floor space was legal. The house has a certificate of occupancy for a home with 2 apartments, which arguably is a more intense use than what we have here. And certainly, this is very similar to some of the decisions that you have granted in the past, because your analysis in looking at those decisions is that there'd be little or no change to the character of the neighborhood. The outside appearance of the home is not going to change, and the benefit to the applicant was greater than any detriment to the community. So, for example, in 121 Cold Spring Point Road, a September 7th, 2023 decision, the facts are virtually identical to the facts that we have here. So in that case, the applicant was represented by counsel when they purchased the home. The property had a very old certificate of compliance that simply stated move the house to a new location, similar to our very old certificate of occupancy, which is a little unclear on the uses. The third floor existed when the applicant purchased the home, and they had a letter from a prior owner of the home indicating that the third floor was in existence, similar to the 2 letters that we have here. So if you look in your package of materials, we have prior homeowners Elizabeth Bell and Alexia Lucian, who remembered the condition of the home and the existence of the third floor. And then we have another. Those are the 2, sorry. Elizabeth Bell and Alexia Lucian submitted letters that they're fully familiar with the house and its condition. We included the floor plans that you asked for in the materials. And then, I know we talked about this a little bit, but there is additional evidence within the home that that third floor was in existence. We found the dates on the skylights, that they're the installation dates, also on the electrical panel, all indicating the early 80s. So really nothing has transpired in that space other than routine, painting and, just updating of the space. And so just to go back to the most recent decision by this board, in that, the applicant in that Cold Spring Point Road decision produced an estimate that the cost to demolish the third floor would be substantial, and they also produced evidence from real estate agents about the value of the home with that additional space. And ultimately, the board decided that, there was no detriment to the character of the neighborhood. Little or no change, the outside appearance isn't going to change, and they granted the variance. And there's a number of others that the board has granted similar variances. And I think it's because there are a few homes that were built in a time period where these, half a stories existed and people used them for living space. And unfortunately, sometimes when people are buying a home and they didn't realize that the space wasn't CO'd. The thing here is that, if the board grants the variance, it's actually a benefit because the benefit to the community and to the applicant, because they're going to install sprinklers, right, which is a safety feature that's important to have in the house. And certainly, as this board has done in other decisions, you've conditioned the decision on if you ever demolish, if the house ever comes down, certainly you're not going to be able to rebuild that third floor, and you can't expand it from what currently exists now. So, I'm happy to go through the other decisions with the board if you want me to and point out their similarities, but I think you get the point we're trying to make. And certainly I think I can't take credit for the presentation. My client did a lot of digging and a lot of work to try to figure out sort of the history of this property and sort of the background.
Nice job with the renovation.
Yeah, I have to say that I very much appreciate this presentation. This is exactly what we need in order to assess these applications. I think it was very clever to get the dates on the skylights. That's crazy.
Well, you were asking about that last November.
Oh, yeah. No.
You know, I think you've done a very nice job, and you have sort of convinced us about the history on the third floor, and that this isn't something you know, just recent and whatever. But I do say that we would absolutely condition any variance on the no expansion, and if the house comes down, there's no variance approval for a third floor.
We understand
Absolutely.
So,
And spring.
and you'd have.
And I also appreciate your
You'd have to make it in
estimate
compliance with the fire
that it
department.
actually itemizes everything, because we've seen like, estimate with a name, and then it says $100,000.
Yeah, no.
You can see my clients have really improved the property from the 20,
No, it's beautiful, nice
from the
job.
listing photo.
Very well done.
What year was that house built?
18.
We don't
We don't know.
We don't really know. Like somewhere initially 1886, then like 1920, and then time. Yeah.
So it's always had that same roof line.
Yes.
That's what it was always said.
Okay, so it's always been, and so there's no, there's no change in the outside appearance of the house or
No.
anything like that. It's
There's
just,
a woman who lives across the street who I think has lived there for 40 years who has the side exterior. It's the
Has
same
not
house that's always
changed
been there.
okay, John, this is yours. Oh, wait a second. Is there
Yeah.
anybody in the audience who wishes to be heard on this application? Is there anyone on Zoom who wishes to be heard on this application?
Okay.
Okay.
I move to close the public hearing on this application, hold it open for written submissions for September 20th with a written decision on October 3rd.
Second.
Mr. Leonard?
Aye.
Mr. Macedonia?
Aye.
Ms. Kane?
Aye.
Mr. Revy?
Aye.
Mr. McDonald?
Aye.
Ms. Burgess? Chair votes aye.
Yeah, thank you.
Thank you.
Thank you. Good luck.
Okay, number 15 on the agenda. Thank you very much. Application of Marie Daly, 9 Pine Road, Noyak, Suffolk County Tax Map number 900-5-5-29.
Is there anybody for this application?
Is there anybody on Zoom?
Peter, is there anybody on Zoom for 9 Pine Road?
Marie Daly,
Marie Daly?
I don't see it.
Vesta Design and Development. Okay. We'll second call it.
Yeah, just come back to those two after we
Yeah, we'll
finish.
come back.
Yeah.
Okay, number 16 on the agenda, 3310 Noyak LLC, 3310 Noyak Road, Noyak, Suffolk County Tax Map number 900-14-1-66.5.
Right.
Good evening, members of the board. Timothy S. McCauley of Council of Burke and Sullivan, 41 Meeting House Lane, Southampton, for the applicant. I think when we met on August the 1st, since there were so many new members, I had asked the members to maybe go back and look at the November hearing. I don't know if you had a chance to do that.
I think everyone made an effort.
I have.
Yeah.
Been here for a while.
Yep.
Okay.
So what's
just-
new?
Huh?
So what's new?
What's
We
new?
got the planning board report.
Well, what's new is we have the secrets in now, and there was a question as to whether or not the planning board had reviewed this. We did a pre-app.
Yeah, I gave a memo that said the planning board did the neg deck, and
Negative.
supports the affordable housing.
Right, and then on the referral issue, we did a pre-app, it's expired, and it wasn't exactly what we're looking for now, it was a lot. There were 5 extra apartments that we're not doing. So, I don't know if you have any questions on what happened there. I would point out, Candace had asked that we change the elevations on Lucy's plans because They weren't exactly the same. I think they were off by a couple of tenths on the average grade. So we corrected that. I submitted that all to the board on August 23rd. The whole package. I don't know if you have it or not, but there were 2 full-size plans and 10 reduced plans for the board. But I know Candace is
I remember that.
Okay,
Yes.
I know Candace is having surgery, so I don't know if everything's getting distributed.
None of those changes would affect the application or the issue.
No, it was just the one page. She just asked that.
Right,
She wanted
exactly.
it to coincide with the site plan, so we
Exactly.
fixed it.
Right.
Other than that, that's all. The July plans would be the final plans.
So if I may just
Yes,
interject
okay.
so the board understands. So in this particular case, what we have is an issue, then we're looking at, when these things pop up in the zoning code. The planning board acknowledged this in our review. The way the code is written, you can't have more than the 4 dwelling units on the one property. This is Hamlet Commercial or Hamlet, it's one of, which the zoning is?
Hamlet Commercial, I believe.
Which
Hamlet
allows
Commercial
for
Residential.
Yeah.
And so we realized, particularly when you're doing multifamily, 4 units on a piece of property doesn't make any sense.
Right.
And now, if we have 2 buildings with 4 in there in each, it would not make a shred of sense to subdivide those properties, put 4 units on each property, when you have an affordable housing development that's multifamily. So we are gonna look at the code to see if we're gonna make some changes to this, because if you have a yield and a density based on how we calculate it, then you can't really have a limitation of 4, when you allow 1 per 10,000 square feet of lot area.
Yeah.
You allow 1 per 10,000 square feet of lot area, but you can't have more than 4 on a property. It doesn't make sense.
You know, obviously it was tied to the 10,000 square feet for the Hamlet Commercial, but we're 108 square feet
Right.
here. And, you know, to make it affordable, make us go through
The subdivision doesn't make
the
any sense.
subdivision, doesn't make
So
sense.
at this point, the position of the zoning board would be that we would grant the variance, whereas you're gonna go back and take a look to see if we need to make some changes in the code.
Yeah, and we're gonna do the site plan for this. We'll deal with the landscaping and all the lighting stuff and design and all that.
Right.
Tinker with it.
Right.
We'll tinker with it.
Well, I've been around since this started. Yeah, I mean, well, yes, I was on the board when you first came before us.
Yeah,
I think
same me too.
Were you on?
Yes.
Oh, John was on and I know Helen. But I have no
I think
problems
John-
with this.
I've always been in favor of this
Yeah.
application.
This was just a matter of
This is a great
getting a lot of
application.
the stuff together that we needed to get together.
Would
So
it be helpful for me, for the board, for me to send a letter, maybe to Katie, of what I think the variances that are necessary?
I think it's be clarifying because, you know, it's been such a long period of time. You know, things have changed. Yes, I think that would be very helpful and we could do it as a written submission.
Okay, I'll do that.
Yeah.
Okay.
Katie, do you
Is that
agree?
all right?
I don't, sure, if you want.
Yeah, do it as a
Yeah,
written
I think
submission so that we don't,
just to
we
make
don't
sure-
tie you up any longer is what I'm trying to
Right,
suggest.
but
that
I
we-
want to make sure that we cover everything that we need.
I totally agree. I totally agree. So that would be very helpful. So this is mine, I think, right?
Yes.
Okay, so here's what we're gonna do. We're gonna close the public hearing finally on this matter. And we're gonna hold it open for written submissions, which will include your list of what we need to do.
Okay.
Until September 20th with a decision on October 3rd.
Second.
Mr. Leonard.
Aye.
Ms. Kane.
Aye.
Mr. Macedonia.
Aye.
Mr. Ribbon.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Aye. Thank you so much.
All right,
You've been
thank you
very
very
patient.
I'm used to it.
Okay, thank you.
Thank you.
Number 17 on the agenda, Dileep Patel and Sabjeet Kaur Dillon, 147 Edgemere Drive, North Sea, Suffolk County Tax Map Number 900-31-1-3.2.
This has been around a long time.
Okay. All right.
While we're waiting for them to go on. Yep. While we're waiting for, hold on 1 second.
One second, please.
John, did you want to stay on this application? When we had previously heard it, you had recused yourself, I believe, because you were new, not because of,
I don't even have the application.
okay,
I've
but,
never,
but you don't have any conflict with this application. application.
No, but I've never reviewed it.
Didn't we
Okay.
get some
I know.
materials recently?
No. I
I
never
got
got-
something from Candace.
Okay, let me resolve my issue with John. So John has no conflict with this. John is not recusing himself on this. The reason we reopened this is because it has been on for a decision for some time. We were waiting for the Conservation Board. We got everything we needed, but there's not enough board members who are familiar with it to vote on it. And that's why I brought you back to just tell the board what the application is about.
So thank you very much.
Let me swear you in, please. Excuse me. Are you an attorney? Okay.
I'm Mark Shipper, architectural engineer.
Okay, well then I have to swear you in. Do you promise to tell the truth, the whole truth, and nothing but the truth?
Absolutely.
Okay, please state your name and address.
It's Mark Shipper, 53 Grove Street, Southampton, New York. And I apologize, I really meant to be there tonight, unfortunately, I had some trouble arranging that had to be changed and I couldn't make it. So this application has been going on for quite a long time, and one of the reasons is how long it took to go through the wetlands. Property has a very large property that has an enormous pond right in the middle of the property. And the couple who bought that property recently, they have two children that are
Anthony, can you bring this one up?
16, 17 children, and they would like to add a bedroom. And in order to add the bedroom, we came up with a design that would require to have an encroachment on the pyramid. The lot is essentially 60% or 70% at home. The house is very close to the wetlands, and it is a waterfront property. It's absolutely a beautiful property. So we're proposing just to add a room on the left side of the property when you look north, and that would be a reduction in setback and a small encroachment of the pyramid. We thought at the time of when Mr. Grossman was the co-chair, we thought we were going to have a positive outcome, and we were going to have an approval, and somehow there was delays and delays.
Well, I think part of the delay, right, was that you had secured your wetlands permit, right?
Yes, exactly.
So the wetlands permit that was issued is consistent with what's before the board, right? What you had proposed is what the conservation board had approved.
Yes.
Okay.
I think there was some change from what they had originally proposed, a slightly
Yes.
smaller footprint and some other things, but essentially the same.
Right.
And-
There was some change, but we had to adjust further wetlands agreement.
Right, so.
And since the
Big wetland.
initially.
And the whole dark area.
Water there. and
I'm sorry, I couldn't hear you. I couldn't hear you. Could you say it again?
I said, initially, we did not propose to change the septic system, because the septic system is very close to the pond, but, Marty insisted that we include the upgrade of the septic system. Even though, based on the number of bedrooms, it was
Okay,
not needed. So this is one of the changes.
okay. So,
And we got the support of the neighbor on the side where we are asking for the relief.
right.
Now, there was one neighbor who had questions, right?
So
There's more than one. I think there were a bunch.
On the south of the property, that's actually on the road on the other side of the pond, thought that the extension would block this view.
Right. Yes, no, there was definite neighbor concern, mostly about the pond, but I think that's been taken care of by the Conservation Board, wetlands permit. Yes.
And I mean, that's typically what it is, right? I mean, the board typically waits for the conservation board, and once the permits are granted, the board feels more comfortable because Marty has, for whatever reason, moved it somewhere. Sometimes Marty, encourages the applicant to go up, right, instead of out, because you're still preserving the wetland setbacks.
Right.
But again, because I knew that John says he didn't even have the application, and we had new board members.
I know nothing about
And,
this application.
but that's why it makes sense, because the first time we heard it, or when they came back, John, you were new and you recused yourself. So we clearly never gave you anything.
Well, no, they never came back. I was never
No,
here
they
when
never,
it was on.
they never came back because
No,
they
but
had.
they did, because we had a couple of Zooms. You had Rick Fernan. Rick Fernan represented them. We've Zoomed with these guys a couple times.
Yeah, but they had to flag the property, then the
Correct.
conservation board, so there was like a long delay.
Yep.
So Katie, what I'm a little concerned about, because I read this pretty carefully and I didn't take an enormous amount of time to compare it to the original. But, I think we need to, again, be specific into what exactly we are being asked to grant a variance for. And that would be helpful if they could give us a list. Is it exactly as originally presented, or is it modified by the wetlands permit?
That's exactly the question I have.
Yeah.
I would rather know, I care less about the history, and I'd rather know what it is we're looking at right now that somebody wants a decision on.
Yes, right. So, is it possible for you to, as a written submission, possibly, unless we think we need to hold it open again?
That's the others.
I don't know, but I would like to know specifically what variances you are now requesting, and I assume that they will be consistent with the wetlands permit.
Yes, basically there are two. One is the side yard setback, and the other one is a pyramid yard.
Right. Right. Okay, but we need to know the exact numbers on that.
It's 5 feet on the side yard, and the encroachment is approximately, it's called 1,300 cubic feet.
How much?
1,300 cubic feet. And this is really meant because of the architecture of the building and the consistency of the original house.
But Mark, you must have the plans there. What's the exact number for the pyramid? We advertised it as plus or minus 1303.62.
That's exactly right.
So it's 1303.62.
And you just said 1,300. What is it?
Yeah.
What is it now?
It's 1303.62.
Okay, so it's still 1303. 62. And the setback, total side yard setback of 24.9 feet, where 40.5 is existing.
Well, yeah, but that's not really, see that, there was a previous variance that had been granted, but we are asking on this variance, it's only 5 feet on one side. The overall side, the setback variance had been granted in the original built house.
I'm a little confused by that because you're asking for one side, you wanted a 5-foot setback variance. But what is the total side yard variance now with that 5-foot setback?
What happened is that the house, when the house was constructed, the variance was granted for the total side yard.
And that was for 40.5? Was that 40.5?
Yes.
Okay,
No,
so
west-
now,
No, west. No, let me clarify.
Okay, well that's what Susan was saying.
I'm trying to get to the point that we need exact numbers that you want us to act on.
So yeah, just send a written submission. I feel like Rick Fernan did put all of that together, but again, there's been such a disconnect between the new board members. So just send a written submission, refer to the revised survey and the revised date of the plans with those two pieces of information, the total pyramid and the principal total side yard.
Exactly, okay, fantastic.
Does that make sense?
Yes, that's what we need.
Well said.
Yeah, absolutely, that makes sense.
And those are the only two variances that are being requested?
Yep, and that's what they were before. It just was, again, securing that wetlands permit.
Yeah. Okay, so since I'm going to take this as I'll set our time frame here. So we're going to say written submission. Oh, is there anybody else on the board who wishes to be heard? Anybody in the audience? Anybody on Zoom who wishes to be heard on this application for 147 Edgemere Drive?
No one else on Zoom.
Okay, so I'm going to say that we're going to hold it open for written submissions, which will include specifics on what you want us to approve.
Can they do that in 2 weeks?
Yes, and I'm sure he has it. You can do that by September 20th, I assume. Okay, with a decision on October 3rd.
And is there a survey that will have these?
Yeah, when you do the written submission, please submit the most recent survey as well.
And the pyramid relief, I need to see, I don't have any documentation on this, so I'd like to see what pyramid relief is being asked for.
Okay. and
Like those two
like
things.
the plans that show.
The
okay.
plans and the, yeah.
Okay, perfect.
And then we can move forward.
Okay, that sounds good. So you'll submit the survey, the pyramid relief plans, and then we'll have specifics on how much variances you're asking for.
Yes.
Okay, that sounds good. Did I have a second on this?
Second.
Mr. Leonard.
Aye.
Ms. Kane.
Aye.
Mr. Macedonia.
Aye.
Mr. Revin.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess.
Aye.
Chair votes aye. Okay,
Thank you.
thank you.
Thank you so much.
Okay, going back to
Second calls.
second call, number 11 on the agenda, application of Joseph G. Wagner III Irrevocable Trust.
Anybody on Zoom?
No one on Zoom.
Okay. Marie Daly? Anybody on 9 Pine Road on Zoom?
No one on Zoom.
Okay. Maybe there was just some confusion.
Should we move to
Yes,
adjourn them?
wanted an
Yeah,
adjournment.
I think you should adjourn them.
To what?
I think we do have room on September 19th, because Candace says there's only 12 on that day.
Yeah.
So I think you should just,
Okay.
you know.
So
I'd love
I'll
to say
move
take
to
a
adjourn
vote,
number 11 on the agenda, the application of Joseph G. Wagner III Irrevocable Trust to September 19th.
Second.
Mr. Leonard?
Aye.
Ms. Macedonio?
Aye.
Ms. Kane?
Aye.
Mr. Revin?
Aye.
Mr. McDonald?
Aye.
Ms. Burgess? Chair votes aye.
And then I'll move to adjourn number 15 on the agenda, application of Marie Daly to September 19th.
Second.
Mr. Leonard?
Aye.
Mr. Macedonia?
Aye.
Ms. Kane?
Aye.
Mr. Revin?
Aye.
Mr. McDonald?
Aye.
Ms. Burgess?
Aye.
Chair votes aye.
Okay, now we're on to decisions.
Okay. Let's see, Julie, you've got a decision?
Yes.
You wanna-
Daniel Rosenblum, Suffolk County Town Map 900-341-1-17. This application is for property located at 22 Bay Avenue, East Quogue. The applicant requests variances for the placement of a proposed detached garage pool within the required minimum and total side yards on a lot that is already improved. This application passes the standards set forth in New York State town law and the town code. Therefore, this board grants relief from Town Code Section 330-76D, placement of accessory buildings, structures, and uses in all districts, and Section 330-83C, yards, to allow a proposed detached garage pool to be located within the required minimum and total required side yard for the principal building as shown on the survey prepared by Rayner Marks Carrington Surveying, last dated March 4, 2024, and the floor plans and elevations prepared by Ben Rosenblum Studio Architecture PLLC dated March 8, 2024, and revised sheet A3.00 received by this board July 15, 2024. The grant of the foregoing relief is subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of the subject premises.
Second.
Ms. Kane?
Aye.
Mr. Leonard?
Aye.
Ms. Macedonia?
Aye.
Mr. Revin?
Aye.
Mr. McDonald?
Aye.
Ms. Burgess? Chair votes aye. Okay, Kevin, you have a
I have
decision.
Timothy and Constance Cassidy. Okay, here we go. Motion for Timothy and Constance Cassidy, Suffolk County Tax Map number 900-46-1-5. This application is for property located at 35 West Trail Road, North Sea. Applicant requests relief from a proposed detached garage on a flag lot with challenging topography. This application passes the standards set forth in the New York State Town Law and Town Code for a variance. Therefore, this board grants relief from Town Code Section 330-76D, placement of accessory building structures and uses in all districts, and Town Code Section 330-83C yards to allow a proposed detached garage to be located within the required side yard for the principal building on a non-conforming lot as shown on the survey prepared by David Fox, LS, last dated September 5th, 2023, and the plans and elevations prepared by Sean F. Leonard, RA, dated December 21, 2023. The grant of the foregoing relief is subject to such conditions and permits as applicant has already acquired or may otherwise have to require for final approval of the subject premises.
Second.
Mr. McDonald?
Aye.
Mr. Leonard?
Aye.
Mr. Redmond?
Aye.
Ms. Burgess?
Aye.
Mr. Macedonia?
Aye.
Ms. Kane?
Aye.
Chair votes aye. Okay, I have two decisions for, one is Richard Reiner Trust, Suffolk County Tax Map 900-54-2-46.1. This application is for property located at 611 Narrow Lane, Sagaponack. Applicant requests a variance to legalize a third story constructed within a one-family dwelling, where testimony and evidence was presented that revealed that the third story to have been in existence since the late 1970s. Under this set of facts and circumstances, this board finds that the application passes the standards set forth in New York State Town Law and Town Code. Therefore, this board grants relief from Town Code Section 330-6 General Regulation that references Town Code Section 330-11 Resident District Tables of Dimensional Regulations to legalize a third story constructed within a one-family dwelling where a maximum of 2 stories is permitted, as shown on sheet A2.3 third floor plan prepared by FSG Architecture PLLC. Given the circumstances and applicant's willingness to limit the variance to the existing third story only, this decision is conditioned upon the square footage of the third story not being expanded and the third story not being rebuilt should the existing dwelling ever be demolished. This decision is further subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of subject premises.
Second.
Mr. Leonard?
Aye.
Ms. Kane?
Aye.
Mr. Macedonia?
Aye.
Mr. Redmond?
Aye.
Mr. McDonald?
Aye.
Ms. Burgess?
No.
Okay, chair votes aye. And I have, the second one is Helen's, but I'll read it for her. This is 43 Newtown LLC, Suffolk County Tax Map 900-188-1-11. This application is for property located at 43 Newtown, Hampton Bays. Applicant seeks a minimum variance for a front yard setback for a dwelling that was built in the wrong location due to a surveyor's error. This application passes the standards set forth in New York State Town Law and Town Code. Therefore, this board grants relief from Town Code Section 330-6 General Regulations that references Town Code Section 330-11 Resident Districts Table of Dimensional Regulations for a principal front yard setback of 37.2 feet where 40 feet is required for a one-family dwelling on a non-conforming lot, as shown on the survey prepared by Twin Forks Land Survey, last revised January 25th, 2024. Grant of the foregoing relief is subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of subject premises.
Second.
Mr. Leonard.
Aye.
Ms. Kane.
Aye.
Mr. Macedonia.
Aye.
Mr. Redmond.
Aye.
Mr. McDonald.
Aye.
Ms. Burgess. Chair votes aye.
Motion closed.
Is there a
Second.
Mr. Leonard.
Aye.
Oh, I'll just say, all in favor?
Aye.
Any opposed? Carries, motion carries.